Someone make it make sense.
Probably a couple.
Hello, squirrel friends. How are you guys doing? What a day it was today. Yes, indeed. But we are here and we're going to talk about it. Welcome, Flash. First one in the chat tonight. Love it. I saw a number of you guys just not that long ago. Squirrel Crew was keeping it real and showing up in full force during Anjanette Levy's live stream. And it was awesome seeing so many of you guys in the chat. I saw Twiz. I saw Meg. Let's see, Scotty Metalhead was there. Kane was there. Trying to remember that. I think there were others of you guys. Northwest was there. Anyway, if I'm forgetting anybody, I apologize, but loved seeing all of y'all in the chat. That was super awesome. Hi, Mary. How's it going? Welcome, welcome, welcome. Happy to see you as well. So yeah. Today was this. And we do have a couple new docs as well that already somehow, like lickety split, are from today, and they're already on the docket. So we have those. We have a number of the still pictures that the AP was allowed to take. We read that filing last night about the still photographs that they were able to have the Associated Press there. So we have those, and I think there's some other things we have. We have a lot of things. We have all of the things. Welcome on in, James. Happy to see you. Flash was watching a courtroom in Africa. That is awesome. What a great idea. I would love to see what that is like. What did you think? And where in Africa? Wow, that is amazing. He Makarna. I have no idea what that means, but happy to see you, James. Second like, bragging, but love it. Feel free to brag about being the second like. So, why don't we just start off with a couple little things for funsies here, just to sort of cleanse our palates for a moment here. How about...
You also told them that you thought you heard a wildcat, but maybe it was a person or something like that as well?
No, that's not what I said.
What did you say then?
I said when I went outside that there's a house cat that's gone wild, and he hangs around. He goes from hanging around the shop, goes from hanging around the house. Different times you might, and there'll be times you don't see him. And he had been around the house, and when I went outside, I believe that cat was over there.
House cat's gone wild, guys. How about this one?
Whenever I talk about this theory that I'm like, I don't even know how to explain it because it makes no sense. We'll say one more time. We'll put two more seed. This is it. This is the whole thing right here. This is it.
I'm trying to tell her that this is a big deal. Like if we go to the police on the second extortion, they're going to catch the second extortion, and when they catch them, they're going to turn, and the second extortion is going to turn in the first extortion. And then when you catch the first extortion, the police are going to come talk to us. And then when we tell them what happened, you're going to be in a lot of danger. There's no way I can talk to the police. So by catching the second, it's going to turn in the first. And that's exactly what I say in there.
That makes perfect sense, doesn't it, guys? So here's the command we have for Charlie Adelson with the triple extortion theory. And I do have some really big news, but I'm going to wait for more people to get here so they don't miss it. No, you guys feel free to guess, but eating chicken, wrong. And if I were to say hot versus cold, like that game, way off. Very cold, very cold. So Flash said it wasn't a courtroom in Africa, but the judge was African. That's still pretty cool, though. I mean, I would love to see a courtroom in Africa. I mean, now that we're talking about it. I raise chickens now. Love that we're on the chickens train, but nope, I don't raise chickens, but that would be cute. Love chickens. I ate fast food. I'll give you guys a hint. It doesn't have anything to do with food, but keep your guesses coming if you want to. I think that's a fun game. So today at the law firm, it worked out because I don't usually take, now you're running a law firm. you're getting more closer on the right track, but not the running part. So I don't normally take like breaks, but I made sure, and I'm allowed to, in fact, like I'm supposed to, but whatever. But today I was like, I'm going to take my break at 1:00 and I'm going to watch this because it was expected to be an hour. It's like, I'm going to take, quote unquote lunch, and I'm going to watch this hearing. So I watched it live. And, in case you're wondering, I didn't watch it. I wasn't in the chat anywhere. What I did, I need to text Twiz. Speaking of Twiz, I was texting with Twiz and just watching it, because I didn't want to be distracted or whatever, and watching it. And it was very surreal. It was a very surreal experience. And then, to go from that back to doing things for the law, as it were. But let me send Twiz his special text so he doesn't miss this. Because last night I forgot to send him a special text until I was rolling the outro, and I was like, "Oh, sorry, Twiz." So where is it? While I'm sending that, let's find something else. Let's do another fun thing here, just in celebration of 2 cases that had resolutions today. We'll just say that 2 cases that we know of that have been talked about on this channel. One more than the other, obviously, that came to resolutions today. So let's do this one.
And boy, you're busy bee on that phone and right out of the gate at 9:02, right?
Am I a busy bee?
Yeah.
I am using my telephone.
So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees.
Okay, here we go. Send this to Twiz. Twiz texted me earlier. He says, "Guess what?" And I said, "What?" And he said, Hi. Okay, I sent him a special text, so everything is right with the world again, at least as it goes with Twiz getting his special text. I got a job promotion. That's pretty close, James. I mean, kind of, in a way. I'm interviewing Lori Val. Yeah, right. That is really close to being on the right track, basically. So I guess I'll go ahead and share that news. So yeah, that too. So basically, if you guys remember the story about how I started working at the law firm, and there was another girl who had been the paralegal for like 2 years, and she'd worked at the DA's office and all that, right? And she was, a full-time salary position, but she was taking a prolonged leave of absence, and there was not really an exact time frame as to when she would be back, and what would happen when she came back or whatever, right? But she was there for the first like 2 days or whatever that I started working, and then she was then gone, and I moved into her office and just sort of took over the job, right? Because like, what else am I going to do? And so like right off the bat, they're having me review discovery and filing things and doing all these things, right? And so and what was happening is I was supposed to be paid hourly, right? That was the agreement. I had hourly pay, right? So there's actually quite a few big newses, but this is the first one. First big news. So then last week, something really funny happened where one of the attorneys, Chris, said, can you like turn off the phone, like the phones, right? Because the phones that ring, the phone rings, right? And I normally answer it. And he was like, can you turn off the phones? And I was like, oh my God, what? Because he's never asked me to do that before. So I turned off the phones and I was like, oh my God. And he's like, come into my office. And I was like, oh my God, what's happening? So he I go into the office and he closes the door and he goes, have a seat. And I said, okay. And I'm like, what's happening? And he was like, so when we first hired you here, we were just kind of expecting you to just answer the phone, and, right? And he said, within your first day, he said, we knew you were going to be a great fit, but you have far and away exceeded any expectation that we could ever have for you. And he said, already in like my first week that I was there, he said that already I had completely done way more for them than, Amy. I feel terrible for Amy, than Amy did in the 2 years she worked there, you know, even though she's older than me and had worked at the DA's office and had all this experience and he said that the two of them were like, they were calling me like Superwoman or something. They nicknamed me. But here's the thing that I thought was the best of all of it. Here's what he said. And these are two attorneys that love their jobs, right? They're very passionate. The thing that left the biggest impression on me was he said, ever since you started working here, he said, Scott and I have never been more excited to come to work. He said, we look so forward to coming to work every day. We can't wait to come to work. And I was like, if anything, I mean, that just, you know, can't get any better than that, right? So basically he said, you know, you're not being compensated for your work here. I mean, and I'm just sort of summarizing. These are just the high points, I guess, if you could say, right? The key things. He was like, you know, he said, I've even told his best friend is the DA in Forsyth County. He said, I've even been bragging to the DA and all my friends about how great you are and and like, basically, you know, you need, you know, we want you to be full-time with salary, with benefits, and with options, you know, going forward with lots of opportunity for growth. And he, you know, he elaborated a little bit. And the first thing I said was, what about Amy? And he said, well, you know, he said, Amy will, you know, he said, we'll deal with it. Right. He said, we'll rip the Band-Aid off, you know. You know, she is in a position where she's a single mom now with 3 kids, having lost her husband. And, you know, it was difficult for her to maintain the hours and all that and whatever. And basically kind of saying like, I think this will be a good thing for her as well, because, you know, she can take some time and whatever. And he said, but basically he said, you know, with the work that you're doing, he said, you know, you know, the 2 ways that we want to show you how much we appreciate you is, he said, 1 is respect and 2 is money, you know? And like, you know, I never asked for any of this, and I never expected any of this. This was not a plan. It wasn't like the plan. I guess the if you will, like the plan would have been, if you will, that whenever Amy came back, I would just go back to just answering the phones and she would take over with all the paralegal stuff. Right. But it's like, I am doing all of those things. I'm doing more than Amy ever did. And they're having me do stuff that they normally do. And basically like, they're like, you deserve to be compensated, you know? And so you know, and then he was like, but before I went, you know, talk to Amy or whatever, he was like, first of all, are you interested? He was like, do you want this? And I was like, are you kidding me? Are you kidding me? I mean, I couldn't even believe it, you know? And so I was like, yeah, you know, absolutely, you know? And so he was like, okay, like I'll talk to Amy and and we're going to get this in the works. And so this change to being full-time salaried with benefits and whatever started yesterday at the beginning of the month. But tomorrow, I believe, is when I'm actually going to find out we didn't even talk anything about like whatever. I'm like, I'm not picky. I love this job. You know, in other words, I don't even know yet what all is going to be a part of this promotion, if you will, but I will find that out tomorrow, I believe, is what Scott said. It's basically whenever they have time, the 2 of them, to sit down with me, you know, and because they're so busy. So, but that should be tomorrow. And then I'll find out exactly what all the dealio is. But yeah, like basically he was like, you know, we want you to be here and you have all the opportunity for growth, and like anything that you, any legal education that you want, we'll pay for. Now they didn't say law school specifically, right? But you guys know that has been something that I've talked about as like the dream, the pie in the sky dream would be getting to a law firm that appreciates me so much that they pay for me to go to law school, and then I can come back and be partner in firm. Again, we didn't talk about that specifically, but they already are paying for me to get like my notary so I can be a witness for affidavits and stuff, and I'm already registered for that and like other stuff too. The other thing too is there's like a North Carolina certified paralegal course, and you guys know I have my certificate, right, through Barbary, but the North Carolina certified paralegal thing, they doesn't count, because with that particular North Carolina thing, they only let it count if you do all the stuff in person, right? Because they're so dinosaur behind the times, as you guys know is common. And so like basically, if I want to do that, like I have to go and take in-person classes. And I was like, I'm totally willing to do it. And he was like, but you don't have to. And here's what he said. He said, you know, if you wanted to and whatever, like we would pay for it. He goes, but to be honest, he said, you would be bored because it would all be redundant for you. You already know everything that would be taught from that program, right? And it's like a whole semester or like, you know, 9 months or whatever. Like you go and you register at a college that has it and you do all that. He was like, I just don't know that it would be worth it because you wouldn't learn anything new. And to that end, I have to say huge appreciation from me to LawTube, because a lot of what I learned initially and still learn is from LawTube, right? You know, of course I do my own studying and I took that course and everything, but I mean, a lot of what I have learned is, I mean, just huge, you know, it's just great. It's just great. So that's part one. And also thank you for everyone else who's saying nice things in the chat. Also welcome to anyone who's just now getting here, including Tanel, welcome. And so, but then here's the other big news is, guys, so I am probably going to be going to two trials in September. All right. The first trial. So Chris and Scott, you guys have heard me talk about. Now, Chris has a wife named Amy, who's the other partner for him. But she works from home, and she's like one of the most sought after attorneys. She has a very niche practice that she does. And she's so sought after that she has not been accepting new clients for like, I don't know, for like years. She has like a certain number of clients that she takes. She's very picky. And these are cases that are huge and go on for years. And so I have seen her a little bit. She's coming to the office, but you know, she just does her own thing from home. And anyway, but she's got a trial the first week of September. That's a huge deal. It's been years in the works. It's civil. It's a civil trial. And she brought in another attorney to be her partner attorney for this trial. And apparently this attorney is like really well known, and he's done a lot of high profile cases and And that trial is expected to last about a week. And she asked me if I want to go and be their legal assistant, like them two and me, and do this trial with them. But maybe even more exciting was today I was talking to Chris, and he's got a first-degree murder trial set for September. And the thing is that it may end up in a plea. And that is sort of, actually, I was helping him work on that today, because basically how that one goes is this dude had a co-defendant, okay? And this is actually really relevant when we were talking about negotiating plea deals, and how I was saying the other night how like it's really different when there's a co-defendant, right? So this dude had a co-defendant, and the co-defendant, the other dude, had way more liability, and so they were both initially charged with first-degree murder. However, the dude who Chris represents, being that he had less culpability, he was gonna testify, right, at the first dude's trial and basically not even throw him under the bus, but basically he was going to be a lot of the state's case in terms of like who did what, right? And and the deal they were going to give him is they were going to knock it down to second-degree murder, but like the lowest level. And so he was going to get a really good deal for testifying against the other dude. Well, on like the eve of trial, he says, I can't do it. I'm getting threatened left and right, because these are dudes that have like maybe some gang connections. He said his life's being threatened, his daughter's life's being threatened, and he can't do it. And he like chickened out, basically. He's like, I can't do it. And so Chris had to go to the DA and be like, I have some bad news. And this was like a huge part of their trial, right? And so I don't remember what ended up happening with that co-defendant, but because of that, right, he lost his deal. So the dude that Chris represents, because he backed out of that deal, he's back on first-degree murder. So essentially what we were working on for him today is we were trying to work on a package to put forth, because of the fact that plea negotiations had previously been talked about, right? But his trial is set for September. And so he's trying to put together a package for the DA to say, hey, look, we were going to have a deal and then but like, can't we just still work something out and basically figure out, like, looking at the sentencing scheme, like, can we agree to this much? You know, he pleads to this and then he does this much time, basically. And so the factor as to whether or not this will go to trial is going to be basically when we get the response back from the DA, because this defendant doesn't want to do time, understandably so. he was in custody for a while, and then he finally made it out on bail. So he's out. He's out. He's like living life right now, apparently, right? He's like out living life. He's not in custody. And so it's the type of thing where it's like he might be willing to, if they can work out a deal where he does 6 years, I mean, which is like a really good deal, right? Like it's like if 6 years, he'll probably do it. But if it's like more than 6 years that they are going to offer him, he would rather take it to trial. So I helped him put together the package, and we submitted the package today. So once we get a response back from the DA in terms of how much they would want to sentence him for and like what they would let him plead to, and then he runs that by the defendant, then we will confirm for sure whether or not this is going to be going to trial. Now, if it goes to trial, it's going to be really interesting because Chris said the defendant will have to take the stand. And again, this is a first-degree murder trial, that he'll have to take the stand. And the other thing that's really interesting is that there's a lot of video evidence from when this murder happened. A lot of people got their phones out and filmed it. And I was looking at this today, guys. And the thing is it's all on camera, but the people that were filming it, the bystanders, had it pointed to where you only see people from the waist down. So there's like a puzzle of like trying to figure out who everybody is based on their shorts and their shoes, right? Everyone's wearing different outfits, and it's like, who's wearing what outfit? And the way to sort of figure that out would be to compare it to other videos. And so basically there's like all these really interesting factual things that if it goes to trial, it's going to be really fun. It's going to be really fun. And I'm going to help him with all that. So anyway, I got to see sort of how all the sentencing scheme works in North Carolina and all that. That was really cool. And but the first trial, the civil trial is unless they settle last minute, which could happen. I mean, but anyway, it looks like it's a definite, at least one trial, but maybe two. And if of all things, you guys know, I couldn't be more excited to be a part of a first-degree murder trial. And Chris is trying that by himself. So it would be him and me at counsel table. It's just crazy. Like I can't even fathom things. So anyway, that's big news that is going on. And so, yeah, so thanks so much, guys, for all the wonderful things y'all are saying in the chat. And welcome on in Meg. Welcome on in DSN is here. Haven't seen you in a hot minute. I'm so happy to see you, DSN. Woo! We need to do this for DSN because it's been a while, hasn't it? Let's see here. Let me get his command. And the thing is, too, right? Like all this experience is just really giving so much more context, and I'm learning so much and getting all this practical experience that it just, I feel like with every single day, it's like my knowledge is like times a million in terms of how I understand the things that we talk about on this channel, right? I mean, it's really like, again, the plea, negotiating a plea, perfect example, right? The timing of that. So anyway, so for DSN here, here we go.
Hey, he's got a bird in his mouth. It's a guinea.
There's a chicken.
And we may as well, since we're on that one, we may as well also do.
There's a house cat that's gone wild.
It's gone wild, guys. Freaking love it. And DSN says he's learned a lot from me. I appreciate it. I'm so glad. Learning is awesome. That learning is squirreling, as I say. Mary says, I knew nothing before I found Chelsea. She changed my life. You guys, thank you so much. I'm just glad y'all are here. I love all of you guys so much. You guys all contribute and make this the reason that I do it, and the reason it's fun, and the reason why people love being here in the chat with the Scroll Crew. I mean, the Scroll Crew would be nothing without you guys. And I mean, that's what we got. We got the Scroll Crew. The more you know, for real, right? It's a chicken. So yeah, so those are some fun things. And, you know, it's it's going to be interesting too, to see the package that they offer me tomorrow as well. You know, all this stuff, it's just crazy. It's just crazy. And I mean, they're going to be like, I'm going to end up with like business cards, and I'll probably be on the website and like, you know, all the stuff. But like I'm managing all these case files from the moment somebody calls. Like, I mean, every single day I get people that are charged with something like a first-degree murder, or what we call the alphabet assault, which is in terms of the sentencing, it's basically akin to a first degree murder. You can end up with life, but it's ASWDWIKI. There's a bunch of, I can't even remember. There's all those letters. So basically what it stands for is assault with a deadly weapon with intent to kill or inflict serious bodily injury. So it's like the acronym for that. And so they call it the alphabet assault. But anyway, that type of stuff. I mean, you know, like I had somebody call today and it's like, oh, you know, I need an attorney. And it's like, I like, look them up on the docket, look at their charges. And I'm like, this is insane, you know? So, but I help all the things, right? I file the notice of appearances and then I file the motions for discovery, all kinds of stuff. Like, I'm doing expunctions entirely on my own. I'm doing, waivers, for different things entirely on, as in like, I literally am filing them and signing them and like sending them off and all that. Right. I mean, there's like tons of things that they, like anything that that I can, like, I'm just doing it all. Like, and then whenever they have like anything that if they've got another motion or something like that, they've drafted, they have me proofread it. And, you know, I don't know. It's just, you know, and then reviewing discovery. And you guys, the other day, I haven't even told y'all this. The other day, what was it, Friday? Y'all. Because, you know, they do federal cases as well. This is insane. So there's a federal operation that's going on. And it has a really cool name, but I can't say the name of it because it's still ongoing. That it's like a nationwide thing. It's like an undercover drug operation, right? And so one of the people involved is the defendant and is being represented by Scott and charged federally, right? And I got an email from the U.S. attorney on Friday sending me all of the discovery, and it's like multiple terabytes worth. Like I mean, or maybe it's like 1 terabyte, but it took up an entire external hard drive that was like a terabyte's worth. And like Scott's like, okay, yeah, there you go, that's free. There's the discovery. So you know how it's always disorganized, right? He's like, do you want to just go through and just sort of see what's in there and then just like let me know what it is? You guys, I couldn't even believe what I was saying. The first file was all these different interrogation videos. Like, what even is that? Then you had body cam videos. Then you had FBI and SWAT team body cam videos. Then you had pen trap and trace. Then you had Title III wiretap and social media, all of this for all these different defendants, because it's like a huge operation, right? And then it was like, oh, what was it? The undercover, it was like the bump in the Adelsons, right? Then it had all the undercover videos where they do the undercover like buys, you know, for months and months and months. And it shows them, you know, the feds like going in and buying these drugs and whatever. I mean, like, so it's just like, I keep thinking to myself, I wish you guys could see what I'm doing because y'all would be so excited. Oh, did Twiz pop on? Is this what I'm seeing? Is Twiz finally using his co-host status? Hold on.
Why are you lying? Why are you lying?
What am I lying about? I can't even believe it. It's a miracle.
There's lots of lies going on here.
What are you talking about?
I don't know. I'm just actually kind of sad you noticed so fast. I just wanted to come in and call you a liar. But you were like on it, like that.
Yeah, I was like, what is this thing? Meg is saying, don't make me go live, Chelsea. Wait, what are you referencing? Hold on. The late nights. I know. The problem is, guys, as y'all know, I'm still teaching. I'm still teaching. It's like, I'm like, you know, in other words, basically, I get so excited when I come home from work that I'm like, I'm going to go live. And then it's like, sometimes I have lessons after. So I just have to like manage I just don't have as much time because, you know, huge full-time job that has a long commute. But anyway, Twiz, how are you doing?
I'm doing fantastic. How are you?
I am doing fantastic as well. I'm so happy you're finally back.
No.
For round 2 of your co-host status.
No.
Meg has a question for you, Twiz.
It took way too long. What is it? What's the question? Read it to me because I'm doing something at the moment.
Twiz, did you get my message?
No.
That's a no, Meg. Mary says, what is happening? What is happening, Mary, is before you found the Squirrel Crew, there was a special day where Twiz, and because we were in a celebratory fashion, Twiz came on for the first time, and I made him co-host, which means that he has the ability to pop on anytime, as he's doing now. And I also made him a mod. It was like, that's why he's the mod. It's been this whole joke. Actually, I kind of forgot about it because it was like a joke for a long time. Like, when's Twiz going to come back on? Like, da da. So this is literally, and that was my God, when was that? 6 months ago, maybe 8 months ago. Anyway, this is the second time he's utilized his co-host status. And so he also has the ability to pull up comments and to put media clips on, the little videos and whatnot that I have, and to pop on anytime. And I'm just so glad he's here. Woo! He's doing something.
I'm here.
What are you doing? Are you having yogurt?
No, I do have empty yogurts next to me though from earlier.
What flavors?
Cherry.
Ooh, that's nice.
I got kind of lazy. Like the strawberries are good, but you have to mix them up yourself, and the cherries just come pre-mixed. So it's just so easy.
Yeah, just so easy. Well, there you go. There you go. For anyone who doesn't know, Twiz has been balling lately. He's building some computers to sell, right, Twiz?
Not yet, but
not yet. He's going to. That's the first step. The first step is the wanting of the thing.
I mean, now there's no trial to go to, so yeah, might as well start. You know what I'm saying?
For real. Now, having said that, some of you guys might be aware that Donna Adelson's trial and this trial were supposed to start one day apart. So I was like, how many times can I clone myself? So in a way, that works out because we can follow that. And then additionally, Shanna Gardner's trial, I think, is supposed to start in October. So, there will be other trials. There always are other trials, and we will be carrying on. Of course. So, and the other thing too is after July 22nd, we should be getting like a fuck ton of new information in this case because things are going to get unsealed, right? And the gag order is going to be lifted. And if you think about all the filings that were sealed and imagine them being unsealed. And it's like, oh, maybe in a year we can get through them, right? It's like a fuck ton. So we'll have lots to go through and we're going to learn a lot. So even though there's not a trial, there will still be plenty. So welcome, Kimmy, as well. Happy to see you. This is typing in the chat. How have your workouts been going these days, Twiz?
I've been super lazy.
It's been super lazy.
I'll get back to it,
and shout out
though.
to Too Fast. Happy to see you. He was wondering how you could keep up with a 3-month trial, right? So that worry is now off of your worry plate, as it were. Where's Heather? Anyway, I haven't seen her in a hot minute.
I think she's crying somewhere.
Crying?
I'm just kidding.
And where's Kane? I thought Kane was around. Mary says if you count the dog I've taken up lifting this week, that is freaking hilarious. That's hilarious. How funny. Keeping some of them sealed and documented. You mean one of the filings? Or what are you referencing there, Meg? I mean, they said the gag order and whatnot, all that's going to be in place until this sentencing, right? But I don't know if that's what you're referencing. Actually, we may as well. Let's just jump right on in. Let's take a look. And Twiz, if you want to read any of this, let me know. Twiz reads. It was an idea from a long time ago. So where is it? Okay, here we go. So these are the two new ones that we have. Yeah. So we'll start out with the plea agreement, I suppose. So, oh my God. I was going to say make it bigger. That's what she said. And then I was like, that's too big. And that's not.
It's way too small on my screen.
Well, what are you on your phone?
No, I wonder if I can mess
Can you
with
read it
and make it bigger.
Make it bigger. Wait, hold on. We have a thing for that. Fievel, where are you? Hold on.
It's very big.
There we go.
A little bigger?
I can zoom in more because we want to do Twiz reads. So how big do we want bigger? Let's go down a little bit so we can see this. Here we go. What do you think?
The state of Idaho, by and through the Latah County Prosecuting Office, Attorney's Office, the defendant, Bryan C. Kohberger, and the defendant's attorney, Ann Taylor, stipulate to the following plea agreement.
Sorry, I'm so excited because this is Twiz Reads. We've dreamed about this day. Twiz Reads is happening, guys. Mary says, that's it. I'm making a drink. All right, I'm going to scroll down. Here we go. Yes.
All right, you do number 1.
Okay. I'm doing number 1, guys. The defendant will enter guilty pleas to the following counts: burglary, Idaho code, and then we have the statutes. I'm not going to read all the statutes. So we have burglary, a felony in count 1, murder in the first degree, a felony in count 2, murder in the first degree, a felony in count 3, murder in the first degree, and a felony in count 4 and murder in the first degree. Why is that labeled differently? Probably a typo, am I right? And then we have a felony in count 5 as stated in the indictment. What's count 5 as stated in the indictment?
That would be a murder charge, I'm sure, or burglary, but burglary was the first one listed, so it's got to be murder.
Right. So it's just, this is listed weirdly. And it doesn't say the statute on that one. So we've got burglary and then count 1. Okay. So they listed burglary first, but burglary is count 5. That's really confusing because count 1 is murder. So counts 1 through 4 are the murders. Burglary is count 5, but they named it first. So that's how that goes. All right. You want to take it away, Twiz?
I'll do number 2. The defendant will be sentenced to 10 years fixed for count 1.
All right. Number 3, the defendant will receive fixed consecutive life sentences for counts 2 through 5.
Whoa, you can read that?
What?
You're good with Roman numerals. Count 4. The state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursements in an amount to be determined, period.
TBD. And that will be brought up at sentencing, right? So, okay, I guess I'm number 5. Defendant understands A, the nature of the charge to which the defendant agrees to plead guilty and acknowledges that he is not being coerced into entering his plea of guilty. B, the consequences of pleading guilty, including the maximum penalties that may be imposed and any mandatory minimum penalties. And that C, by pleading guilty, he waives his rights to a jury trial, to confront accusers, and to refrain from incriminating himself. Loses his Fifth Amendment right. Defendant further acknowledges that he is satisfied with his legal representation, has reviewed with his attorney all possible defenses, and by his plea of guilty voluntarily waives those defenses and all claims based upon his constitutional rights. That's terrifying language right here, right? All claims based upon his constitutional rights. I don't like to see that. It's just like that terrifies me. But okay, that's what you're waiving. That's a lot. All right, Twiz, you're up.
Wait, go up just a little bit.
Just a little bit. Just the tip.
All right, stop. The defendant further acknowledges that he is satisfied with his legal representation and reviewed his attorney's possibility guilty voluntarily waives those defenses and all claims upon his crazy. All right, let's do number 6.
Yeah, it is crazy, right? Okay.
Defendant understands that if we're to proceed to trial, he would have a right to appeal, including but not limited to any issues decided by the court prior to defendant's guilty plea, including any rulings on the admissibility of evidence. B, the judgment, including the finding of guilt and any issues regarding the guilty plea. And C, the sentence. Further, the defendant understands that if were to proceed to trial, he would have the right to file a motion under Idaho Criminal Rule 35 seeking a reduction of the sentence. The defendant hereby knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in this case and waives the right to file a motion pursuant to Idaho Criminal Rule 35.
Well done, Twiz. Well done. Let's give Twiz a hand for his reading. Huh, guys? Round of
Dude,
applause.
reading is hard.
Reading is hard, and Twiz has really mastered it, I shall say. So I see what you guys are saying in the chat. So as far as, okay. I mean, I think that in Idaho, I'm fairly certain that it's kind of like in other states, right? Like, for example, like South Carolina or Florida, like life means life. Like, in some states, it's like they have to specify, is it with parole or without parole? I'm fairly certain, and we can double check, but I'm fairly certain in Idaho, it's the same way where life means life. So it's just life. It's just LWOP, right? But let me see if I can pull it up. Actually, let me do this. I'm going to read number 7. And then when Twiz is reading number 8, I'll try to pull that up just to verify, because you guys know how I am. If I'm even one smidgen, I don't remember last time I looked that up, we're going to look it up. All right. Oh, well, that's okay. Number 7.
No, I call this one. I get number 7. I get number 7.
Okay.
Number 7. This is the entire agreement and understanding between the parties. Period.
Try to read those signatures.
William Thompson and Taylor.
Good job. So, all right. Yep. In Idaho, a life sentence means a person will spend the remainder of their life in prison. Yep. For first-degree murder, this can be a sentence imposed instead of the death penalty with no possibility of parole. That's even if you don't, in other words, I was correct. Life means life. In other words, even if you don't take a plea deal, regardless of whether a jury finds you guilty or you take a plea deal, regardless, if you're doing life in Idaho, it's life means life. Second-degree murder is the one where in Idaho where you could get a minimum sentence of at least 10 years. But first-degree murder, your options are life without parole or the death penalty. So don't go to Idaho or don't live in Idaho, people. That would be what I.
Well, at least don't go to Idaho to murder people, especially when you live in Washington.
For sure. And Meg says Twiz is the most sus. Love it. Any of you guys that are members, don't forget we have the custom emoji, and one of the custom emoji is Twiz. So DSN says, good reader. We got some applause. They'll get that. Thank you. Thank you. We're showing some love for Twiz. Love it. So, all right, on to the next document, guys. Idaho, where life is life. That could be their slogan, right? You know, when you go to a state or whatever, it has like the big sign and they all have their little sayings. Like, okay, hold on. What would Massachusetts be? We're gonna have to think about this. What would Massachusetts be? I do love Idaho, where life is life. What would Massachusetts saying be if we got to pick it? You guys can think about it. All right, next up. So when I was talking to Twiz, texting with Twiz during this hearing, I was not expecting this to be what it is. I was expecting this to be the way that it was with the state, which is like a narrative, right? And that's the way it sounded like when it was brought up in the hearing. Anyway, basically what I'm saying is this is not at all what I expected, because it's like an optional thing, right? Like we went over last night, we went over the plea forms, right? And like having this separate written factual basis is not part of that. It's not required. And based upon how it was referenced in the hearing, and then based on how we saw the state do it, I was expecting this to be his version of the narrative of what happened. And literally that's not what this is. So, all right. I guess, is it my turn? I think it's my turn. So I'll read the first paragraph. So I hereby admit responsibility to count 1, burglary, which requires the following elements. On November 13th, 2022 in Latah County, state of Idaho, the unlawful entry of a residence located at 1122 King Road, Moscow, with the intent to commit the crime of murder. So they've added in here, right, the intent to commit the crime of murder, because with the burglary statute here, right, it's like the way that they were charging it, it was the thing where it's like, you know, unlawful entry, but in the commission of another felony. You guys remember we talked about that in length, but this was a long time ago. And so that's why they've added that, because you might be like, wait a second, to burgle doesn't mean you have to also have intent to murder. Correct, it doesn't. But that's part of how they are charging this. Okay. Twiz, you're up. Paragraph 2.
I hereby admit responsibility to count 2, IC 18-4003A, murder in the first degree, which requires the following elements on November 13th, 2022 in Latah County, state of Idaho: the willful, unlawful, deliberate, with premeditation, and with malice aforethought killing and murder, Madison Mogan.
Well done, Twiz. Well done. Also, we have some great suggestions in the chat here for Massachusetts. Massachusetts, where dirty is clean. Massachusetts, where sidebars are not just an alcoholic drink. Welcome to Canton, drunk drivers and other law enforcement. Massachusetts, where lying under oath is required. That might be my favorite, but I love them all, and you guys are amazing and super funny. And also, welcome Need Some Z's, who says she's late. She's pissed. It makes no sense. Feel free to share your thoughts, and also fun surprise because Twiz is here. Woo! Interesting. So Too Fast is saying, assuming the way Bill read out that story, that is the order that they were saying. Right. So I do think that when he reads the, you know, again, states, what do they call it? The factual basis for the state, that would be showing, yeah, what they would have, what the state contends they would have shown at trial. And I do agree with what Too Fast is saying here, that that's what the state was going to attempt to show in terms of the order that they were slain. I think that that is true as well. And that would have had to come out through like an expert, like the medical examiner, and, you know, and other what means too, right? But that would have come out. And so notably, the charges here, are the charges in the same order as what was suggested? Very astute. Yes. And so these charges, right, count 1, count 2, count 3, and 4, they are in the same order as what was suggested at the hearing by Bill Thompson. So yeah, great point. Thank you, Too Fast, for that. Great point. So, okay, it's my turn now, I believe. So what am I doing? All right, here we go. Count 3. I hereby admit responsibility to count 3. Murder in the first degree, which requires the following elements. On November 13th, 2022, in Latah County, state of Idaho, the willful, unlawful, deliberate, with premeditation and malice aforethought, killing and murder, Kaylee. Why are we missing the preposition here? Don't we need the word of? Like, it's just weird. I'm going to add it. Killing and murder of Kaylee Gonzalez. All right. Next up for Twiz. Count.
You get an F for reading. You can't insert things where you want to.
That's not what she said.
Oh, shit.
Yeah.
Anyways, I hereby admit responsibility to count 4 IC 18-4003A, murder in the first degree, which requires the following elements. On November 13th, 2022, in Latah County, state of Idaho, the willful, unlawful, deliberate, and premeditation, or with premeditation and with malice aforethought, killing and murder Xander Kernodle.
All right, and now we have count 5. I hereby admit responsibility to count 5, murder in the first degree, which requires the following elements. On November 13th, 2022, in Latah County, state of Idaho, the willful, unlawful, deliberate, and with premeditation and malice aforethought, killing and murder of Ethan Chapin. I plead guilty. Oh, sorry, that's your turn. You go, Twiz.
I plead guilty to counts 1, 2, 3, 4, and 5 of my own volition.
Well done, Twiz. Now, I thought it was notable that, look at this, is interesting, right? So I appreciate the being thorough, because this said June and then he crossed it out and put parentheses July. But this is interesting because, in other words, this was drafted in June, right? Now, Monday, what was Monday? Was Monday the last day?
Well, the previous document was signed on July or June 30th, and this is on June.
Oh, you're
July
right.
1st,
You're right. You're right. Thank you for noticing that. Yeah, 30th. That makes sense. So then I see. I wonder, interesting. Yeah. So they drafted these at the same time. He corrected that for the record. There's his signature. And yeah, so let's see what you guys,
I think I know why the order was written like that.
Why?
Simply because Ethan was last and no one ever talks about him.
So, I mean, well, that's
the
sad,
truth.
isn't it, though?
Yeah, he's a
I mean, you're
dude.
right,
Nobody
you're
cares.
right. Well, I don't know.
Everyone always says that guy that murdered the girls in Moscow, a dude was killed too. Nobody cares.
Well, I don't ever hear it like that, but it probably depends on where, where circles you're floating around in or whatever. I mean, if you're on like the social medias, I have no idea, because you guys know I stay far away. I mean, with us and with, where we interact with each other, I think that I don't know that we would state it that way. But I will say, of everybody, right? I think that it seems like Kaylee gets talked about the most, right? Would you guys agree? Of all the victims? Like, do we hear the most about Kaylee? I feel like we do.
It kind of depends. Because, I mean, like, most of what we hear about is, like, from Steve or something. Like, he obviously talks about her the
and
most,
that's
but then he talks about her second. But, like, outside of that, most people assume that his target was Maddie.
Yeah. And the thing is like, I think you're right. And that's, I agree 100% that because, Steve has been the loudest, the most frequently, what's the right way to say this? has been frequently talking about the case, right? And then therefore it's like, yeah, connects to Kaylee and Maddie second. I think I agree with that as well. Mary says, I just hear the 4 kids. There you go. Yeah. Yeah, Meg, because her dad is everywhere. You said it better than I did, Meg. Well said. Yeah, the parents are the most vocal. Yep. So, okay. I also have some pictures that, like, we know the AP had the still photographer. So I also have some pictures. Do you guys want to look at those now, or do you want to start watching the hearing and then look at the pictures later? Or Twiz, you can weigh in on that. What do you think?
I mean, I don't care.
Okay. Well, let's start with the hearing then. And then, we will pause it to comment on things. So let's pull this on up. Pull it on up. Okay. Do you guys want closed captioning? If so, I can put it in the middle so it doesn't block anything. Let me know in the chat if you want closed captioning, and let's go. That's true. That's true. Sorry, I already have something I have to say. Did anyone else notice that it looks like they rearranged the courtroom? Like, look at the defense counsel table, right? You see where they're located? I think they moved them because normally there would be people sitting behind them. Like, you see what I mean? I think they rearranged this. And I wonder if
They're in a different room.
Oh, okay. All right. Thank you, Twiz. Twiz, who has been there.
I'm pretty, well, maybe they aren't, but I'm pretty sure they are.
Does he usually have his 2 computers like this, Hippler? I feel like
I don't think so. It's really hard to tell because where the cameras are, like if that is the same room, like you can't tell by the cameras. But where the defense is sitting, that looks different.
Yeah, that's different.
I was assuming they were in the same room that Chad Daybell was in, but this doesn't look like the same room either.
This is way too small. This looks like the one they're usually in, but they, where the prosecution.
No, it can't be. It can't, because isn't that a window behind the defense?
Yeah, but see, they're not usually over there. Or are you saying that room doesn't have windows?
Yeah, because there isn't a window there.
Oh, okay.
Yeah, it has to be a different room.
There's no windows anywhere in that room?
No.
Okay.
It's like squashed in between other courtrooms or something.
Okay.
Like, I don't know if it's just courtrooms or there's like hallways between them or something. I have no idea, but like it's between different courtrooms.
Twiz, you're saying you were born in Idaho? That's not true.
What do you mean it's not true? I was born in Boise.
You were? I must have blocked. I don't remember that. I thought you were born in Washington.
No, I grew up in Washington.
Okay.
I was born in Idaho, moved to, I think, Montana when I was like 2 for like a year, then Oregon for like a year or something, then to Washington from like 3 or 4 to when I went to Arizona at like 27 or something.
So, yeah, I mean, it's like you were doing the Lori Vallow tour, right? Between Boise and Arizona. I'm just kidding.
Well, now that I'm caught, I've always been a huge Lori fan, and I followed her around.
There it is. The truth comes out. Truth comes out, guys.
What a day for the truth to come out. Am I right?
Well, at least it came out somewhere for something. Twiz is a big Lori fan. You heard it here first, guys. Too fast to say that. It seems like more of Hippler's hair has fallen out since the last hearing. Yeah, you know what? His head is especially fluorescent, reflective. I think you're right about that. Okay. Well, we will sally forth.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings. And Mr. Nye is here as well. Am I miss anybody?
Do you not know their names?
He's
Because it seems like he struggled a little bit with their names.
Alan is here as well.
Miss
Your
Allen
Honor.
is here as well. Very well, thank you.
Lord of mercy.
All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case.
This blew my mind. I did not know this was going on until I heard this live. And I was like, what? People were trying to contact him?
No, Steve Gonsalves went on line and was like, anyone who knows Hitler, call him and tell him to not let this plea go through.
Oh my gosh. Does he know it was Steve?
It's on video.
But do you know, I mean, we don't know that he watched the video, right?
No, it's on video of oh, are you asking if Hitler knows it's
Yeah,
if it's
Hitler
Steve?
knows, right.
I mean, he was probably told that. I don't know if he watched the video.
Like how awkward, right? Like if like he's saying this knowing that the person who caused it is the victim's dad, like that'd be super awkward, right? Like,
I mean, I guess that's kind of the point of what Steve wanted though, right?
I guess. I mean, yeah, I mean, I don't know. It seems like a lot of his vitriol was really directed towards Bill Thompson, although I don't know. I don't keep up with him. Was he equally as mad at Judge Hitler? Or do y'all know? Those of you who have seen the things? Like, was he like pissed at Judge Hitler, or was he really mostly pissed at Bill?
No, he said he doesn't blame Hitler because it's not Hitler's choice, right? He's just the judge on it. Mostly Bill Thompson.
Okay, Santa. Yeah, but this is just crazy. And then people did it. I mean, it's like, you can only imagine, right? Like, oh my God.
This has been extraordinarily disruptive for court staff.
Yeah.
And the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases.
Yeah, it's just
court should.
It's so improper, and it blows my mind that anybody thought that if they like called up there and left him a voicemail, that it would like that A, he would listen to it, and that B, it would affect anything. Were people really thinking that? I can't wrap my head around it. Twiz, help me out.
People were indeed thinking that.
Okay. Well, there you go, guys.
Apparently, I mean, I haven't heard the calls or anything, but it sounds like that's what was going on.
Yeah. Wow.
And I always will make decisions based on where the facts and the law lead me. Period. I have not read any of the numerous messages, nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this, because again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers. What the court.
The way that I love this, though, because while I don't like, you guys know I don't have the best thoughts and feelings about Judge Hitler all the time. However, the fact that he is spent time from this hearing that is dedicated to changing a plea, right? In this case. And that, like, I was like laughing when I heard this in a good way of like, oh my God, he has to teach everybody like a civics lesson. So he's like, basically, if you read between the lines, he's like, y'all are fools. Let's talk about separation of powers and go back to like 3rd grade where you should have learned how this works. And I just think it's freaking hilarious. Like, I appreciate this actually because people need to hear it. Why? Because as DJ, in the words of DJ Flashy Flash, humans are idiots sometimes. Yes.
Case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon.
Y'all, how shocked were you guys to hear that? Because like that's when we learned it, right? I mean, like, he just said that, but like, wow, right? Monday afternoon, he learned of it. Crazy.
I knew it was coming. That's a lie. That's a lie.
I mean, it's like, wow, right? Like,
I was watching YouTube, right? And the video or live had like just ended, so I closed it. And the next thing that shows up is a video or a live where this dude's like, Bryan has agreed to plea. And I was like, what? And then I Google it, nothing. I refresh YouTube. He's still the only one. I'm like, what is going on? Then all of a sudden everything starts pouring in.
yeah, I did not know about it until I was driving home from work and I was stuck in completely stopped traffic, which happens very often on that drive. And those of you guys who were there for Kane's live stream, literally, I saw that Kane was live, right? And I was like, just stopped traffic. And I was like, oh, let's see what's going on here. So I like popped in the chat. I'm like, hey guys. And I like literally said, I'm driving home from work. I'm stuck in traffic. And then on Kane's live stream, Meg, was it you? People started saying, like, that's how I learned. So I learned with you guys as you, however many of you guys also learned. Kane learned, like, we all learned it together for the most part. Maybe some of you guys heard it slightly before, but in any event, shout out to Kane because I learned the news from his live stream, and he was very surprised. So yes,
Of it beforehand.
Beforehand.
Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July.
Wow.
It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this getting this trial potentially underway on time.
Right.
And including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified.
Makes sense.
And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave.
I'm just pausing it because I just noticed in the who's sitting behind the prosecution there, there's Brett Payne. If you guys can see my arrow, there's Brett Payne, and there's Mallory right there. I don't know who these ladies are. Maybe it's their wives, or I don't know.
No, they work for MPD or something still.
Do you know who this dude is, who I'm circling with my mouse?
I can't tell. Anjanette Levy was there, and she listed off some of the names. I think she listed off that guy's name, maybe one of the ladies, but couldn't remember the other one. I don't know.
Okay, but he's not someone notable, obviously, because we're like, who cares?
Yeah, probably not that we would recognize.
Right. I mean, what really matters is like if Twiz was there or not, and obviously Twiz wasn't there, unfortunately. So
maybe at sentencing.
Yes, great minds think alike. Yeah, that would be great because then we can. We love getting to celebrate and wave at you and yell at you and yay Twiz when you can't hear us. It's fun every time. So did Kane change his name? I don't see him. No, he didn't change his name.
He's not here. We're just shouting him out and stuff.
Right, that's correct. Thank you, Twiz.
He might be live right now, to be honest. He had one scheduled.
Really? Well, let me see here. So is Chad Daybell sitting there? Right. Yeah, Chad Daybell. We know where he is. Let's see. Is Kane live? Like, come over here with us. Oh, he is. I think he's live. Well, here's what we'll do. When we get finished here, we'll redirect into Kane's live. If he has it set up to where I can do that, right now it looks like he's got a puppy video playing on his stream. If he has it set up to where I can redirect, we'll redirect into that. So is BK's dad in the blue shirt?
BK's dad, I believe, is to the left of the guy in the blue shirt. So we can't see his family on camera.
And that's the thing. I think they did that on purpose, right? So all the people that are to the left of like where Brett Payne is, right? Like that would be families. And the reason being, right? And the thing we heard last night, they were ordered not to show like the victims' families and whatnot. So my thought was that like all the family members and friends and whatever would be like on the left, and then all like media and like whatever law enforcement be on the right. Is that what you think, Twiz?
Yeah, something like that. I mean, it was kind of weird because in the other courtroom, when the G fam was there, when I was there, they were just off camera. So maybe they're doing that intentionally. I don't know.
Yeah, I just know that the order that we read about the courtroom photography thing said like nothing and don't show the people. Don't show the people. So yeah. So I'm just seeing if I'm going to be able to redirect into Kane's live. I don't know if he has it set up for that though. Oh, good. He does. Awesome. So I'm going to go ahead and assuming he's still alive, right? But if he's still alive, this after we're done, whenever we're done, we'll redirect into Kane's there, so we can all support him. Shout out to Kane. Wish you were here. So, okay.
Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today.
Oh boy.
I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right,
And the written plea agreement, we read that. Also, what he was just referencing, we went over this last night, the binding versus non-binding. Basically saying like you can't, if you do the plea agreement, right, you can't take it back once you just figure out what the sentence is. But here, I mean, again, that's not really, there's not going to be any surprises, I don't think, with sentencing here. But let's just say in some other case, right, let's just say there was a plea agreement and both sides agreed to 10 years and the judge was like, I'm going to give you 15 years. You can't say, oh, wait, takes these backsies, because it's no takes these backsies.
All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Hold on. Pause. Those of you guys who were here last night or on replay crew, do you guys remember the one thing that, like, we spent a little time talking about it when we went through the forms and whatnot, and the questions that are going to be asked of the defendant? Now, I didn't know that. I mean, we weren't talking about it in terms of being asked of the attorney, of her, but we talked about it when it's asked of the defendant. And do you guys remember what happened when this one came up? Does anyone remember? I'll give you guys a minute to see if you guys remember, and I'll see what y'all are saying in the chat. Was Christy in there? Like, you mean Kaylee's mom? I believe so. Yeah, the camera angles suck. Yeah, the bald guy is Brett Payne, right? And then there's Mallory over here. Something about fish. Not about fish. Yeah, Steve did not attend. He was boycotting, basically. I mean, if nothing else, I guess I appreciate, that he's exercising his constitutional right to boycott something, regardless of what it is or why. Like, yeah, like let's learn our rights. You know what I mean? Yeah. So, okay. So I'll just go ahead and tell you guys. So what it was we were reading those forms, right? And we got to one of the questions on there, which was specifically about enough time to review discovery. And I was like, oh my gosh, I wouldn't be surprised, I said last night, if when this gets to the defendant being asked this question, when it says like, did you have enough time to review all of the discovery in your case? I said, what do you guys think he's going to say? Because like, what if he says no to that? Because that would seem like something that could be a potential thing that would happen, right? Like, given what we know, right? And like, if he were to say no, what would happen? But he's asking Ann Taylor this question first, but there's a pause before she answers it. And her answer was surprising to me.
Discuss fully with him his rights, defenses, and possible consequences to him of the guilty plea.
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon.
There you go.
Or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily. And I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now while you're standing, actually, why don't you take the oath from the clerk?
There we go.
Yes.
It's interesting because he projects really well, even though he's standing, which you guys know how it is with these microphones, right? In other words, he's got no mic anywhere near him, but you can hear him really easily. There's no, they don't have like a lapel mic on him. You know what I mean? He must really have been projecting.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right?
I think also, so it doesn't startle anybody, because who all was shocked when he stood up like that? Like, I was very surprised. I was like, holy shit. Like, normally they physically would have difficulty given whatever they have on their body. Anyway, I was shocked. I mean, but you see that he doesn't have any handcuffs on and whatnot. Anyway, yeah, normally you stand if the judge asks you to stand, but again, he was doing this out of respect. But anyway, I was still surprised. I don't think I've ever seen that before. Mary?
Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of...
I'm going to put it on 1.25 for some of these parts, just because we literally read all this. But yeah, I'll slow it back down when it gets to some of the more important parts.
Incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition,
So I wonder if that was so we pulled that up. That minimum of 10 years on each count, that must have been part of the plea deal. That's not part of the sentencing scheme as per the statute. So I think it was Too Fast who referenced that potentially. And yeah, that is interesting. I'm gonna replay that part. because that is not the standard, right? Idaho life means life. This must have been negotiated specifically as part of the plea deal, which is incredible to me that the state signed off on it.
A period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts.
I mean, it's like, we know he's going to be given life, right? But still, like adding that's not, again, that's not standard. That doesn't come that way. They added that in. I mean, and thinking about it too, right? Like, isn't that kind of crazy? Because like, if you think about like, if not that it's going to happen, guys, but like if he did get 10 years, right? Instead, if he got 10 years, you know, for each murder run consecutively, and then even if he got 10 years for the burglary, what is that, 50 years? So, I mean, in other words, again, this is not going to happen, but
He'd
if
be
they
quite old.
He'd be quite old, but he may not die in prison, essentially, right? So, Mary's back. How was your workout carrying the dog? Hopefully great. So, and I think, did I say welcome to Official, who's changed his name again? We're missing your, you know, your wrench and your bone and your other little trinkets there, Official, aka Skolma Chi.
In addition, you would
It's like Sigma Chi, but Skolma Chi.
Is that what that's from?
I'm pretty sure. I'm pretty sure he thinks he's clever.
Okay, yeah, I would have no. I mean, I'm not saying he's. I mean, I think we can agree he's clever. Can we agree that he's clever?
I mean, I'm not disputing that.
Okay,
but
yeah.
I actually figured that out like last night or the night before or something. I was like, oh, I get it.
It's his channel. So do you have a channel? Is this new, Official? Tell me why you didn't tell us any sooner. And Mary's giving us an update about her dog. Twiz is asking what's wrong. So because we know Mary's been getting a workout carrying her dog. How much does your dog weigh, Mary? Oh, you've released music and some music videos. Awesome. Well, you guys, anyone that feels so inclined, after we redirect into Kane's live stream and after that's finished, we can go check out Official's channel. That's been awesome. Love that. 87 pounds. That is about how much I weigh. So that's pretty crazy. Wow. What kind of dog do you have? That is a lot for a dog. Yeah. Oh, yeah. No wonder you're getting a workout. Doberman. Oh, yeah. It's that Great Pyrenees that'll get you up there in the weight category, right? They're so cute. So cute. Okay. Here we go.
$5,000 to each of the victims of your crime to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
I mean, for sure. Yeah, I mean, I wasn't saying the standing was weird or that there was anything wrong with it. Like, I agree with Judge Hippler. I thought it was a sign of respect. I was just, for me anyway, I was just noting that I haven't seen that before, so it surprised me. When you watch a lot of trials, right, you know, something that is different, it just catches your eye. But I mean, I didn't think it was weird. I mean, I thought it was completely understandable, and I'm honestly not surprised, or sorry, I am surprised other people don't do it. And I have to wonder if it's just because some of them might be like shackled under the table, you know, but anyway.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
The reward is not dying. I mean, really, is what it is.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
There's that.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
You know, I'm wondering if there's not another document we haven't seen yet. You know how I've said that I wasn't expecting this document let me play this again. This document that's being referenced, right? I was expecting this to be a narrative of what happened. Let's listen to this carefully. And then I was like thinking, oh, that thing that was uploaded that we just went over, I was like, that's not at all what I was expecting. But watch it. It's numerous pages. Watch how many pages. Hold on. Let's hear this.
Plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Okay, that questionnaire is what we went over last night, right? We saw that, we went through it, and he's saying, yep, I filled that out. That's what's required. No more is required of a defendant in a plea deal or negotiating a plea. They only have to fill that out. They don't have to do anything else, right?
Understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road.
Now, this is the one that we read that was listed as the statement of facts, right? But he references another doc. So in other words, am I being like confused? Like, wait, what? I think that the thing that we saw was labeled a statement of facts, and that's what he's reading now. But the other thing that he referenced earlier that was not required was something else, and that has not been posted yet. But the context that I have for this, my opinion, is that
without it being, it wasn't required. It seems like Bryan Kohberger wrote an additional statement of that. You know, my expectation is that it would be something that's in narrative form, like what we see, what we expect and see from the state. So anyway, it'll just be interesting to see if that's what that is, and that will be posted to the docket at some point. And anyway, we might, what will we learn? We'll learn something, right? As long as it's not sealed. So welcome on in, Angel. Happy to see you as well.
In Moscow, Idaho, with the intent to commit the felony crime of murder. As to count 2, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count 3, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count 4, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
So he believes those things to be true, essentially, is what he said there. Well,
I want to also make for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis.
This is the thing I was referencing. How did I go back so far? This is the thing I was referencing. Okay, here we go. Here we go. So in addition to that, right? So what's funny is he's calling it a written factual basis, but the document, let me just show you guys why I was like, what? So where is it? Okay, hang on. Here, right? So we read this earlier, right? It's labeled written factual basis, but what this is it's just literally the counts that he just read. But now what he's going to say is that attached with this document right here, there's an attached written factual basis. So like something's amiss here, like this is mislabeled, or I don't know. I don't know what's going on, but basically my point being, it still seems completely like there will be more information forthcoming here. Let me go to the part in the hearing so you guys see why this was such a big deal to me. All right, back to this.
I want to also make for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road
Welcome, Cooper.
in Moscow, Idaho,
You're
with the
fine.
intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you.
All right, here you go. So now's a good point to answer Mary's question. So Mary's saying, how does the redirect work? Do you stay on the screen? So here's what happens when it redirects. What should happen when it works, and it usually does, is when the live stream ends, it'll automatically, it's like taking a portal, like Lori's portal, we call it sometimes, right? It should automatically pop you into Kane's live stream if he's still live streaming, which I think he probably will be. Then he just started. Usually it works. Every now and again, people will say that they didn't get portaled over. So if that happens, you can just go find it or you can go watch whatever. But essentially, usually when it works, you don't have to do anything and it'll just redirect all of us as a scroll crew, whoever's watching, they'll like take us all and transport us into Kane's live stream. And then what'll happen, and you know, it could be any live stream, right? We've done this before with Runkle and whatever. But what'll happen is then like there will be something that pops up in Kane's live stream that says that like Chelsea Whitaker and the viewers or whatever have joined. Like they'll get a little notification or whatever, and they'll see us come in, and it's just fun. That way we can continue hanging out and together and also support Kane. So yeah. Yeah, Kim is saying he sounds almost giddy when saying yes. Yeah, it was very it did seem a bit enthusiastic to me and very emphatic and very confident to me. I'm not saying that that means anything. I'm just saying that's how I heard it. And again, projecting a lot. He doesn't even have a microphone in front of him. Very affirmative sounding to me. Welcome, Candace. Happy to see you. And Cooper, if you're a new Squirrel friend, welcome. We're happy to have you. It seems like you know people in the chat, so that's awesome. And Mary says that she's not on either side because she's not seen enough evidence. Well, yeah, and that's the thing. None of us have, because you know what? We were all waiting for trial. Well, I was, and I know other people were, right? Because really, you need to see the trial to see the evidence before you can make an opinion, right? Or whatever. Or just assess the veracity of the state's case. But now we will not have that chance. But I'm so glad. So Mary's saying that 2 weeks ago, she thought, oh, he's guilty. Look at all the headlines. I'm so glad that you have learned that is not the way. Excellent. The Karen Reed trial really changed my opinions on how I view the presumed guilty. That makes me so happy. That makes me so happy. That makes me so happy. That is huge and means a lot, even though that's not like, you know, it's so important. And I just wish that everybody would have that opportunity, but I'm just so glad that you did. And isn't it amazing to think like, wow, what a difference, right? Like, so, right, exactly. Because it's supposed to be presumed innocence, correct. And you didn't have those feelings until you watched Karen Reed. Yeah, that's, that gave me goosebumps. That's very impactful to me. I can't believe this is how it ends. Me neither. Me neither. I couldn't believe that. This was a very, and it had a weird vibe. Like, I mean, I think we're all probably still processing that this happened, like at all. But like, so I don't know. This was just it. I feel exactly the same way, Cooper. Just of all the ways for this to end, this was just the weirdest one, I think, and very weird.
Is it the end?
Oh, dun dun dun. To be continued. Twiz chimes in.
That's like the funniest thing about this whole thing. Like Howard Blum wrote a book about this, and he said this seems like a cover-up or something. Right? Anjanette Levy was like, what? This crime was so bad and he doesn't have to say anything? Like they're all questioning it, but going along with it, you know?
Right, like questioning the fact that he doesn't have to give more details.
Yeah, I mean, no murder weapon.
Yeah, I mean, the thing is, though, I mean, y'all know this, right?
It's a plea deal.
It's a plea deal, right? And so, in other words, the state could have, like, okay, the state could have asked for it, and they would have had every right to deny that, right? Like the defense, because they can't require that. They can't require that. It's not
right. But then he doesn't get to remove the death penalty. So, like, there's a match there that you could have, you know. Well, if you want that death penalty off, then you have to tell us where the knife is or something.
Well, no, the trade, right, is by getting the death penalty off the table. What he's offering the state is a guaranteed guilty.
Right, but what I'm saying is they could say, if you want the death penalty removed, you have to give us something. And they didn't get anything.
And, well, you know, here's the thing. We don't know what the first draft, we haven't, Okay, there could have been other drafts of this plea deal, right? The talks have been going on. We don't know yet. It is possible that the state asked for that. Let me just think about this. It's possible the state asked for more, but that's how negotiations work, right? Because they might have asked for more, and then the defense said, nope, we're not going to do that. And then they said, fine, we'll just, you know what I mean? Like, that's how negotiations, you're all supposed to ask for more than you think you're going to get. You know, that's what they say. So it's possible that happened and we just don't know about it. But like, essentially that the state could have done that, just sort of like shooting for the moon, knowing that why would the defendant agree to that? And like, literally they can't actually require it. It would be kind of like saying, yeah, like, will you, I don't know, what's an example? Like, will you, I don't know. Let's just say that you're like checking out at the grocery store, right? Or something. There's like the person who's doing the grocery checkout thing. And it's like that person is required to like check out your groceries or whatever, right? And it's sort of like, yeah, you could ask them to also give you a back massage, right? And they could say yes, but they could say no and nothing, and it won't change anything. I don't know. Does that make any sense? It's probably a bad analogy. I don't know. What do you think, Twiz?
I just think that
like, it doesn't hurt to ask, but if you get denied, it doesn't change anything. That's what I guess what I'm saying.
right, but like they're not getting anything. Like, we're going innocent until proven guilty, and like he's pleading guilty. That doesn't mean he's guilty, and we have no evidence that he's guilty.
Right.
I just think it's a little weird.
I mean, my interpretation of it is it's because the state doesn't trust their case because they said as much, right? Again, I referenced this in the video last night, but for anyone who missed it, there was a statement that put out by Bill Thompson to the families, and the first, and I know there were like numerous versions of that statement, but the one that I heard, the very first sentence started with him talking about how, this could very easily end up in a hung jury or a mistrial, which means that was the state literally saying, we don't know that we can secure a conviction. In other words,
why would the defense accept it if knowing that their case is that weak?
did you not watch the live stream from last night?
No, I did not. I did not have time.
That's why you're answering that question. So,
well, I'm not. I'd ask it anyways.
Okay, but I answered. We talked about this at length last night, but I'll talk about it again because I'm sure you're not the only one. Basically, here's my summary of what I think happened here. That the state, it's all about trust. By trust, here's what I mean. The state wanted the plea deal and accepted and whatever, went along with the plea deal because they don't trust their case. Now, for the defense, the thing that they don't trust, in my opinion, is the jury pool. And here's why. When you look at the most recent filings right before this plea deal went down, all of them have to do with the jury questionnaire. That's point one. Point two is, this is the example I gave before. Think about this. Think about the jury, the Delphi jury, the Richard Allen jury. Think about that jury, right? That jury, if the death penalty had been on the table, right, for that case, in my opinion, that jury would have given him the death penalty. Think about that jury and compare that, those of you guys who saw Karen Reed's retrial, to that jury, right? Compare the Richard Allen jury to the Karen Reed retrial jury. Think about how different those two juries are. And remember when Ann Taylor said, it shouldn't just be about one thing. I hope it's not just one thing. And she was referencing the DNA on the knife sheath, right? Remember guys her saying that? I hope it's not just one thing. My interpretation is that the state, again, they don't trust their case. They have admittedly holes in their case. The defense knows it and the state knows it and everybody's on the same page about that. And this is why I even have it timestamped. What does this say about the jury system? I think this is a big deal because here's the deal. When both parties are in agreement that the state's case sucks, right? It says to me a lot about it's more of a reflection on the jury system that the defense would still feel like they need to negotiate a plea deal because they can't trust a jury to do what the Karen Reed retrial jury did, which is presumption of innocence, understand the burden of proof, be objective, and assess everything. Because I think the part that the defense doesn't trust is that the one thing. I think that the defense does not trust that if they get a jury, like for example, the Richard Allen jury, that jury 10 minutes into opening statements hears about that knife sheath and hears about DNA on the knife sheath, and they're done. And literally they're like, okay, we don't even have to listen, right? That's a lot of people. We've heard this. We've seen this. A lot of people, all they have to hear is DNA on the knife sheath. That's it. That's it. He's guilty, right? If they listen and pay attention, like, for example, the Karen Reed jury, they would understand that means literally nothing. That means literally nothing. And they would understand how all this works, right? And they would look at everything. And I think let's just say that he took this to trial. If he had a jury like the Karen Reed jury, I would bet like my arm that he would be found not guilty.
I would bet both of your arms.
Yeah, me too.
For the record.
But if he got a jury like the Richard Allen jury, death penalty, conviction and death penalty, without question. And so the thing is the gamble is the jury. But here's why I think it's such a big deal, because that's always the case. But when admittedly both parties are like, you even hear it from Bill when he goes into his statement of facts here. I mean, in other words, the state needed this because they were not sure they could even get a conviction. But how much does that say about jurors who can't use critical thinking and can't put their biases aside and can't understand the presumption of innocence and are going to be like a Richard Allen jury, that outweighs even knowing the state's case doesn't meet their burden. You guys see what I'm saying? I think that's what it was for the defense. And it's they just can't trust a jury to be able to do their job. And again, the Karen Reed jury was really kind of 1 in a million, guys. I think from what we've seen, they really understood the assignment. And I wish every jury was like that. Don't we all want every jury should be like that? But you know what? I think that jury, the Karen Reed jury, is sadly in the minority. What do you guys think? Let me know. Twiz, you can let me know your thoughts too.
It might be true. I'm not an expert on such things. But I'm wondering if maybe they instructed the jurors differently or something, where like the defense really taught them about reasonable doubt and how it works, and maybe that's why it's different. Maybe it's just that defense attorneys don't do it properly a lot of the times. I don't really know.
I see what you're
Karen
saying.
Reed's.
Oh my God, didn't mean to play that. I see what you're saying. You're talking about the caliber of the attorneys, right?
Yeah.
Yeah. The thing is, though, Richard Allen had phenomenal defense attorneys.
But did they teach them about reasonable doubt enough?
Well, it's hard to say because we couldn't watch the fucking trial. But my understanding is they did. I don't know. And yes, Mary, Richard Allen at Delphi, that's correct. That's correct. So it's clear Hippler is convinced Bryan did it. Yeah, I would agree. And I would think if Judge Hippler were not a judge and he were a juror, my impression of him, this is just my impression of him. My impression of him is he would be a juror who'd come in and hear the one thing and be like, yep, right away. I think he would be one of those Richard Allen jurors. That's just my personal impression of him. Just based on just how what we've seen and his demeanor. And, you know, I don't know that he would be the type of juror that we would all hope to have if we were on trial, you know? They did seem very intelligent. They were very intelligent. And they understood the assignment. They really did. Right. Yep. The Richard Allen, the Delphi, there were no cameras. So the only way that we have any information is there were different attorneys from LawTube that went there in person. Shout out to Bob Mata of the Defense Diaries. Shout out to Andrea Burkhart, and shout out to lawyer Lee. And they were there in person, and they did God's work, as they say, which is, you know, after they sat in trial all day, they went live and relayed what happened, because literally we would have had no idea otherwise. Right. So it was very jarring. Yeah, that was one of the most depressing verdicts for me. You guys have heard me talk about it. I think Flash, didn't you punch something? We've talked about this other times, but yeah, that was a hard one. That was
somebody in chat. I can't remember if it's in here or somewhere else that I regularly go to. They say they knew somebody on Richard Allen's jury, and they convicted him just to give the families closure.
Right. That's not anybody here, but you know what? That wouldn't surprise me at all. And that is literally one of the things that I'm referencing when we talk about juries who like literally don't understand their assignment at all. That is literally that has nothing to do with anything. That is so fucking depressing. I can't even. I mean, sadly, it doesn't surprise me, but it shouldn't be happening. They should be able, through voir dire, to get jurors who wouldn't do that, right? I mean, that's, ugh.
I mean, the weird thing with that is that's just like one. I'd have a hard time believing that you could get 12 to do that. But that one juror said that's why they voted for conviction or whatever.
Right. It's, yeah. I mean, in a way, that's almost worse than being like, oh, one piece of evidence was enough or whatever, right? When it's, because it's like, never mind a verdict, right? As we were saying earlier, the purpose of the justice system, like, this is a hard fact for a lot of people to understand. It's not about closure for the families. And that's why I was saying it's so interesting, right? We also talk about closure and the victims' families and closure. And the thing is that is not the role of the justice system. It's just not. And it can't be, right? The justice system is about justice, right? So that if somebody commits a crime and that crime is proven beyond a reasonable doubt, that they are punished appropriately for that crime. And it's not their job to provide closure. And closure is different for everybody. And it really, at the end of the day, can only come from within each individual on how they process things. What closure means is going to look different for everybody, like I said, but the thing that it isn't. So again, while closure might be different for everybody, and it is, the one thing that it's not is the equivalent of the role of the justice system, if that makes sense. Flash confirming he punched a lot of things. Yeah, that's what I thought. That's what I thought.
Are you going to guess again or not?
Wait, what? Are you talking to me?
Yeah, you're the only one that has guessed so far.
Wait, guess what though?
Guess again.
Wait, what am I guessing?
I said, you know why Andrea Burkhart is awesome? And you said because she's in Washington. And I said, no, guess again.
Oh, okay. Well, there's a lot of reasons why she's awesome.
No, there's one reason why she's awesome.
She loves the same brand of yogurt that you do.
No.
She is an attorney.
No.
She, I don't know. Maybe people in the chat can guess. Because I also have to be keeping up with comments in the chat. So,
she shook my hand. Therefore, she's awesome.
I probably would have gotten there eventually. Right. That's very true, Twiz. That must have been, did she even know that was the best day of her life?
Nope.
Yeah, unfortunately.
I don't think she realizes it today.
We need to fix that. Andrea Burkhart, if you're listening, that was the best day of your life.
I like to act like I'm important and be like, yeah, they shook my hand. Not that I shook them. They shook my hand.
Exactly.
I didn't shake their hands.
That's literally how I phrased it like that on purpose, right? Because of that. Shouldn't there be a counter for what, Mary? Okay, Tanella is saying that was the first offer the state had made. We don't know that. People
are saying that the defense went to the state and asked for
Okay, I'm going to go ahead and clarify that for the record as well. That's not how this works. Here's what I think happened, and maybe when things come out more after the sentencing, we'll learn more. Here's what would normally happen. If the state is going to offer a plea, they usually will do that pretty early on. Okay? Now, what will happen typically is the state will offer a plea. In most cases, that happens, right? They'll offer a plea, and that plea offer is on the table. Now, the defendant, if they accept it right away, then there you go. But if they reject it, it doesn't like go away, right? It's not over. I mean, here's the thing. They can even up until, up until the jury is sent to deliberate, they could still negotiate pleas, guys. Let me just reiterate. They could be in trial. They could finish closing arguments. The deadline to finalize the offer and acceptance of a plea deal is when the jury is sworn in and goes to deliberate. Up to that moment, they could, it's happened. It's happened. A plea deal can be struck. Okay. So just so you guys know that, right? So in other words, that plea deal, it's always still kind of there in the background. And what usually will happen is if the defendant denies the plea deal, rejects the plea deal, at any point in time, they could go back up to the state and say, hey, state, you know that plea deal we were talking about? We want to rethink that. And then at that point in time, the state says, okay, let's keep talking. That is what I think happened here, because that is the normal thing. So when anybody says the defense approached the state, where did that come from? Did that come from Steve? Where did that come from?
I'm seeing it reported like both ways, but I've also seen it said that Hitler told the state to come up with their best and final offer, as well as Hitler told the defense to come up with their best and final offer. So I don't know. I thought the state did it, but
so that what might be happening. So in the hearing, in the pretrial conference hearing from like whatever 2 months ago or whatever, Hitler mentioned when he was going through a whole list of deadlines that need to be in writing before trial, he was rattling a whole bunch of things off. And one of the things he listed was any plea offers that have been whatever. He said it as if a couple things. One, he had no idea if there had been or ever was or is or whatever. He had no idea as to the status of that. It's a hypothetical. And two, as if the way he was listing everything, that was just like a par for the course. Like this was a standard instruction where he was listing this and this and this and this, and then this thing, where not all of those things are applicable, right? But you just have to say them and get them on the record, right? That's how I took it. And I actually paused the live stream and I said, guys, don't freak out. I know he just said something up with plea deals. It doesn't mean there's actually a plea deal. Literally, it's just, this is part of like the instruction he's reading that he reads to everybody. But it was mentioned, but it wasn't mentioned like it was a real thing. And other than that, I've never seen on the record, and what I mean is court filings or any hearings, I've never seen anything on the record where those two words, plea deal, were mentioned at all, apart from that one hearing until now. So I
think Ann Taylor said there would be no plea deal or something at one point in time.
If she did, I don't remember that. But
I think it was in the Franks or the suppression motions.
Okay. I don't know. I feel like we watched those so many times. I would have.
No, it was in a filing.
Okay. Well, but that wouldn't surprise me if she said it, apart from the surprise that I don't remember it, because you guys know what my memory is. But it wouldn't surprise me that she said that. But yeah, in other words, here's the thing. The way that it doesn't work, right? Here's how I'll just tell you how it doesn't work. In this case or any case, how it doesn't work is that the state has not offered a plea deal, doesn't intend to offer a plea deal, has no plans to offer a plea deal, has nothing to gain by offering a plea deal or anything. Like, okay, first of all, let's talk about offer and acceptance. How familiar are you guys with contracts? Because the contract has 3 elements: offer, consideration, and acceptance. You can have more than one, you have to have more than one party, right? So let's say 2 parties. One party has to be, you could think of it like the moving party, the one to make the offer. Plea deals cannot come from the defense, guys. They have to come from the state. The state has to make the offer. Think of it like a contract, like any other contract, okay? The state has to be the one to make the offer. And then the consideration is when the defense is like thinking about it, right? And then they're whatever. Acceptance would be, I accept it. And that would be the defense. And that's for any fucking case, okay? Any plea deal, it's the way that it does not work is the defense goes up to the state and says, hey, state, can you give us a plea deal? Never going to happen. Because here's the thing. If the state's not incentivized to accept a plea deal, or sorry, if they are not incentivized to have a plea, like they would have offered it, right? If there was any incentive for them. And usually where you see it a lot is when there's co-defendants, like I was referencing earlier. When you have co-defendants, there's a lot of incentive there because you want one to flip on the other, right? So oftentimes that's where you'll see it. There has to be something for the state to gain. The whole point of a deal is that both sides should win a little and lose a little, right? So in other words, if you've got a case where the state has a solid bulletproof case, right? Okay. And there's only one defendant, they would have literally no reason to do a plea deal. Because why? Like out of the goodness of their hearts? No. There'd be no reason for them to say, yeah, we're going to just do no, never going to happen. It's only if there's some leverage. There has to be leverage. So in other words, the state is losing, in this case, the state is losing the option for the death penalty. But what are they gaining? They're gaining a guaranteed guilty conviction, not a verdict, because it's not a verdict, right? And again, we know, and we've now heard it on the record, like they don't have confidence in their case. Now, what should have happened is if they don't have confidence that they can win their case or prove their case beyond a reasonable doubt, we shouldn't even be here in the first place. This shouldn't even be happening. The state shouldn't be bringing charges unless they are 100% confident in their case beyond a reasonable doubt. And we talked about this last night. Great example, Karen Reed. While it was delusional, right, with Hank Brennan, he was 100% confident, as we saw it over and over again, even after the fact, that beyond a reasonable doubt, 100%, right? Again, misguided and delusional, but that is what you're supposed to be in your case when you are trying a case and you're the government, okay? So in other words, to me, this shouldn't even be happening, because what should have happened is the case should have been dismissed, or the prosecution should drop the charges, or just charged with whatever they know they can prove beyond a reasonable doubt. For example, if they thought burglary, whatever it is, whatever the fuck it is. But instead, they are all the way to this point here. And now, instead of like, oh, should this case move forward or not? It's like, should he die or not? Right? If that makes sense. So anyway, so offer, consideration, and acceptance, and leverage. Okay. So the leverage here, and the state loses the death penalty, but they gain a guaranteed guilty plea, and the defense gains not dying, not death penalty, right? So that's really what it comes down to. But that's the reason why, like I was saying, the state has to be the one to make that offer, and they wouldn't make the offer if they didn't have something to gain. And then the defense would consider it, and that could go on. Like a plea could have first been mentioned in this case from day one. We just don't know. It could have been there the whole time, and initially it was rejected.
I'm thinking this started about 2 weeks ago.
I mean,
at the very least,
it's possible, but it's also possible it's been there and it was rejected, and it's for whenever, right? I mean, it could have been when all the IGG stuff went to hell in a handbasket, maybe, right? I mean,
I have a reason to say that. I'm not making that date up. I don't know if it's connected or not, but something happened 2 weeks ago.
Oh, Twiz seems like he has some insider information.
This might be why, or when it started, or something.
Also, welcome, Kat Randall. Happy to see you again. Be right back. I got to put the fish and lizards to bed. I love it. That's awesome. Love you for that. The fish and the lizards. Make sure they're all tucked in, and please read them a bedtime story and give them a hug and a kiss on the cheek from me, please. We love all the fish and we love all the lizards. He directed it. Let me just see what you guys are saying in the chat. He directed it to AT.
I think she's saying Hippler told Ann Taylor to get the state's best and final offer. He said something along those lines in a hearing.
I mean, I thought it was make sure that you include any record of a best and final offer. My recollection is not that it was directed to Ann Taylor, but I mean, it's apart from the fact that he was saying these are all things the defense has to turn in by a certain deadline. But again, it was all in a list of other things. It wasn't like by itself. It wasn't like he just was talking to both parties and then turned to the defense and said, hey, by the way, defense, make sure you give the best and final offer. Like, it wasn't like that, right? Like, because the way that it came out, my interpretation at the time was like, this is very par for the course. This doesn't mean that there's a plea on the table. I mean, now that a plea has happened, now I'm like, in hindsight, I think the plea was on the table the whole time, but I don't think Judge Hippler was even privy to that. I mean, and honestly, it makes sense, right? He's like, I didn't know shit until Monday. So I think he just says that, like, that's part of what he has to say to every defense team. You know what I mean? But I do think that, ironically, I think the plea deal was probably already there, but had been rejected. But yeah, what else were you going to say, Twiz, about your 2 weeks?
Oh, that's all I'm going to say at this point in time.
Oh, keeping us on the edge of our seats. Look at that. Keeping us wanting more. Bill Thompson was so confident. He was so confident. And then, boy, oh boy, today was very different.
I mean, it's kind of like poker or something like that, right? You seem confident when you're not, and you play weak when you're not.
Right. Yeah. I mean, the other thing too, though, I will say, is like he did a lot of the arguing and stuff early on, and then we didn't really hear from him as much as, recently. You know what I mean, guys? Like, I think he argued one thing recently, but like he became more of a butt in a chair person. You know what I mean? We heard more from the other attorneys, I feel like, recently. He was really fucking confident that day when they did the jury motion to change venue and they had that Dr. Edelman. That was really spicy. That was like the spiciest hearing. But yeah, I will say he came across to me today in this hearing. He came across to me just personally different than I've seen him in this case. It was a very different demeanor. A lot like this was just such a crazy day. Like everything was very different. Like, but Bill Thompson to me was like, the way I read him, right? I was like, oh my God, this is like a completely different Santa. It was weird. It's like, is this Santa's twin? So, oh, you put a clip there. Where did you put it? Can you put the clip in Discord to know? So that we can hear or we can look at it later. Mary answering the question about her lizard, 6-year-old veiled chameleon and a 5-year-old snow leopard gecko. I know what a chameleon is. Snow leopard gecko. They both sound cute and amazing. I hope that you gave them a little scritchy scratch on the head and tucked them in. Gave them a bedtime story. Love them.
The organization of resuscitation is different than what I think the court and the public may be familiar with from the probable cause affidavit.
Okay, so let me back it up. So let's just remember where we were. So now Santa's going to read their statement of the facts. Okay.
Recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the resuscitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants.
Now, here's what I want to say real quick. That I was when I heard this live, I was like, good for you, Santa. You know, there's not been much I could say that I'm going to like say something that's like, I don't know if you could call it complimentary or whatever, but to Santa. But here's what I will say. He says this more than once, and I really am so appreciative of it. He clarifies. He's like, we're not saying this means he pings at the house. Like what he's doing here is basically saying, here's how we cannot prove our case. Like, let's hear this again. This is basically
he gives so much reasonable doubt in his own thing.
That's what I'm saying. That's the whole thing about the state not trusting their case. The state doesn't trust their case as much as I think the defense doesn't trust the jury pool or their ability to get a fair jury. I think the distrust is why this happened. If you want to think of like the simplest way to understand it, distrust on both sides, and that's why this happened. Oh, Amanda's here. Hello, Super Planet Girl. Happy to see you. It did have a weird vibe. I agree with that.
Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m. on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd.
Bryan is just now joining us, including Amanda, aka Super Planner Girl. Did you know that Twiz is here? Like, Twiz, make yourself heard, if you will.
What? How do I do that?
Perfect.
How do I do that?
For anyone who didn't know, Twiz is here as with his co-host status. So isn't that exciting? Super, super exciting. And he even did, we did Twiz reads earlier. We need to make that a regular segment on the show. I love it.
End of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then moved to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman.
I have to pause it real quick. Thank you, Tanel, for that. So Tanel following up. Okay, so here we go. She says he didn't ask Ann Taylor to go get an offer, just to declare if it was offered. So that's how I was trying to explain it. Hopefully that makes sense, right? Just like if it was offered, we have to get that on the record, right? And hopefully by finding that clip, you can see why the way I referenced it was like, this is just par for the course. It doesn't mean that this exists. Although again, in hindsight, now I think it did exist, but he didn't know it and he wasn't saying it because it existed, if that makes sense, in my opinion. You talked to the troll on the phone? What? That is wild. Wow, that is crazy. Hopefully everything's okay now though, and they're not going to be a dick to you. That would be good.
That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately
this is where the court has a little bit of a technical difficulty, guys. It's the court feed. It's did this on everything. There's a little bit of an echo, but it doesn't last long. But just know it's the court.
48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was.
Sliding door.
Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and
He almost forgot the knife part. Kind of important, right?
Caitlin Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend.
Notice the language, because it's going to come up again here from Santa in a little bit. He says ended up killing her, right? So it's like he went to the third, came in through the sliding door, according to Santa, went to the third floor, right? Killed the two girls upstairs, right? And then it's like was coming downstairs and came across Santa and then ended up killing her. That's the language he uses there.
In their bedroom, in her bedroom, and the defendant killed him as well with a large thick knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house.
So essentially, if you read between the lines of what the state is saying here, is like that they actually don't think he planned to kill all four people. Kind of surprised again. I mean, I guess not really, given what we've seen, that they're making that concession. what it sounds like to me is like the state's theory would have been, if it had gone into trial, that they think he planned on killing, I would say probably one of the two girls that was upstairs, or maybe the two girls, but that Xana and Ethan were not planned. In other words, like that it was happenstance because Xana happened to be awake and he encountered, again, according to the state, encountered her on the stairs, and then like Ethan woke up and like basically, you know, that's what happened. He killed them because they saw him or whatever. You know what I mean? That's what that sounds like. And it kind of makes sense just in the fact, like thinking like, you know, planning to kill 4 people if it's your first time, well, regardless of who it is, right? Planning to kill 4 people with a knife on your first murder is like a really, really ambitious in a bad way. Don't murder people, but like, because most people would probably start with just like one person. Anyways, you guys see what I mean?
And they were already asleep.
I was literally thinking.
During the course of this, one of those roommates awoke, looked out her door, not knowing what was going on, and saw the defendant, who was dressed in black with black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before.
That's not what she said.
At approximately 4:20 that morning,
in a mere 2 to 4 minutes time, according to the state's theory that they would have ended up going through a trial, is what they, you guys remember how that window kept getting small? Like initially when this whole thing first went down and started getting more, it was like it used to be like 17 minutes, and it was like 16 minutes. It kept getting smaller and smaller. And for anyone who missed it, the most recent iteration was 2 to 4 minutes, because that's what they were having to, they were going to endeavor to prove with one of, with the dollhouse situation, was they had somebody try to pretend like they could go through the house in 2 to 4 minutes. And we went through this at length because it blew me away. It blew me away. I was like 2 to 4 minutes, 2 to 4 minutes. Even the 5.
Well, they're saying like the killings happened in that. Part of the original timeline was when he drove.
They're saying got in and out of the house in 2 to 4 minutes. Like that's because the whole thing's like starting from, okay, go. Like,
Can I finish?
Okay, fine, Twiz.
They said originally that the timeline was like from when he got there to when he left. So like he parks at 2:07ish or whatever, and they see him driving away at 4:20, if it's him.
No, they had to change it. They had to change the window based on shit that came because of the fucking text messages with DM and BF. And what,
I mean, they've done a lot. Originally, they said the crime happened between 4 and 4:20. Then it was 4 and 4:25. And then the last time I saw it was between 4 and 4:30. And I'm like, if you have a car leaving at 4:20, how can you say the crime ended at 4:30?
Right.
And Bryan's the one that did it. This don't make no sense.
Right. But the thing, again, that's still notable to me is like that they were like, the task that they gave that dude who they wanted to run through the house, they like, it was clear that they were like, he has to prove it could be done in 2 to 4 minutes. And that's the reason I'm saying we will probably never find out what all reasons that got narrowed down to 2 to 4 minutes. But here's what I will say. They wouldn't have made it that narrow unless they fucking had to, right? Like, why would you, like, if you could do an 8-minute window, why would you do 2 to 4 minutes? Like, you know what I mean? Because it's just not plausible. No one's going to believe it. But if you make it that narrow, it's only because like, that's what you end up having to do when you take everything into consideration. Anyways, so, right. And he doesn't kill DM, correct? I mean, right. I know. It's a great point, right? Because Santa's conceding that he, you know, again, I hate to use the term, but like collateral damage, essentially, right? Bystanders like Ethan and Xana, but like
2 of them were just random because they were there, but you walk by a third one, you're like, nah, I'm good. Make it make sense.
I know, right? I mean, unfortunately, I cannot. So, all right, let's keep going.
So this would have been 15 minutes or so later. Finn's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom were to see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route.
We're going to just
So we know
set
that he
that
went through a
aside.
variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks him back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, this Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up.
Okay, so we're going to set aside the fact that that is completely dumb and stupid and whatever, embarrassing that that's even mentioned. Has anybody thought to themselves, wait a second, that picture, that selfie with the thumbs up, has anybody asked themselves, wait a second, how would that be admissible? Because it's hearsay, right? Has anybody thought about that? Has anybody asked themselves, how would that come into evidence? Because I can answer that question. If anyone wants to know, I can answer that question. Just so you know.
The defendant's phone then went to the Lewis and Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport, large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicle seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania resident.
Guys, do you remember the dad trash days? Oh my God, the dad trash days. Wow, memory lane.
Of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Logan's body.
I knew it, Twiz. I knew it.
Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home and returned to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, in public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking.
Didn't they fucking come out though with like a bunch of computers and like a bunch of like a bunch of technology stuff? That's my recollection. And I remember thinking, wow, it's like a technology. Yeah. So I don't know. Weird.
And they found nothing. But apparently like his porn habits and video chat, which is where they got all those selfies from, that they claim he was trying to act like Bundy or something.
And all that's just complete and utter speculation. I know you know that. That's just so fucking dumb. It's
Well,
y'all,
here's the wild thing. Before
Everybody
Bryan was
has
even
to-
arrested, they're saying no signs of sexual assault in this crime, but somehow his porn habits matter.
Well, and also Santa even already said that there was no signs of any type of sexual crime. He already said that, like on the.
Well, I mean, he doesn't bring up the porn in the hearing, but Dateline
Right.
did or whatever.
Right, and that's the thing. So it's like, in other words, the porn in the state that would never have come into trial. That's the long and short of it. You know what? The Dateline shit is so dumb for a number of reasons, but primarily, I think almost everything that they said is inadmissible, and that's exactly why it's called. That's why it's problematic. That's why it's a leak. That's why it's called taking from jury. It's a completely inadmissible and would never have come in at trial. So, and you'll notice the only selfie, quote unquote, that's even referenced by the state is the ones with the thumbs up that came out through a court filing, right? That, and you know, the rest of the bullshit stuff that came in the Dateline, the state seems to rightfully be ignoring it. I mean, you know, because it's like, yeah, it's inadmissible. It just, and this is exactly why, and like Mary was saying this earlier, this is exactly why these types of like shows and documentaries are so problematic. Beyond being prejudicial and potentially poisoning a jury pool, it's misinformation, it's inaccurate. And I think the biggest harm of all is, honestly, it is the reason why so many people are confused about this country's justice system, right? About what the fuck trials are supposed to be. And I mean, you know what I mean? Like what Mary was saying. And I mean, all of us were at some point, we're in that position, right? Where we didn't know anything. And then you start learning stuff about how it really is. And you're like, wow, all of that is completely awful, right? And Mary's saying, yes. You know what I mean? Like it's doing so much harm to the public, right? Would you agree, Twiz?
I would agree.
Okay, he's still there. It's like, have we lost Twiz? Yeah, it's just, yeah. And the other thing, it's also
Was I
very
freaking out?
Huh?
Was I freaking out?
Were you
You said
freaking
I
out?
was still here. What was going on?
Oh, because there was a pause and I just wasn't sure if you were like still with us, and then you answered. the
Oh,
question.
gotcha. Yeah.
Yeah.
I
but
was
like,
doing something, but
that's okay. You're allowed to do things. But the other thing is just so also emotionally manipulative, right? I mean, you know, those fucking programs that are dumb like that. Anyways, you guys know. Amanda, thank you, wants to know why that one photo would be admissible. I'm glad you asked. Let me tell you guys how it would be admissible. Because you might be like, oh, because so Santa's suggesting something with it, right? He's trying to suggest something about this picture, the thumbs up selfie, right? Da-da. But in terms
and
of
they never say who he texted it to, right? Officially?
no, I don't even know. Do they even say it was sent to anybody? Or just take it?
I mean, not officially, I don't think, but he sent that to his mom.
Here, let me back it up.
Has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket.
Wait, I think I didn't go back far enough or something. Hold on.
Weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was
Wait, I still didn't go back far enough, I guess. Anyways, hold on. We'll get it this
was
time.
not only of the FBI, but the Pennsylvania State Police.
Okay.
Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, in public, the weapon itself, the knife, has not
Oh,
yet.
fuck. I don't know. Did I not go back far enough, guys? Let me answer Amanda's question because I think she's going to bed. So here's why that picture, here's how they could get this picture, and here's how it could be admissible, okay? Because you have to get around hearsay, right? Here's why. Because it comes back to Rule 801, the definitions, okay? So the definitions that apply to hearsay. The first part, right, is what is the definition of a statement? This is key. The definition of statement, and I'm reading this from the Federal Rules of Evidence. Statement means a person's oral assertion, written assertion, or non-verbal conduct if the person intended it as an assertion. Examples might be giving the middle finger, giving a thumbs up. The law considers that to be a statement as if somebody said something verbally. And so why does that matter? Oh, because the defendant's own statements, you know, we always hear their own words, right? But it's a statement. That's all it is. The defendant's statements can and will be used against. So in other words, because it's his gesture, it's a statement. And because it's his statement, he's the defendant, it's an exception to hearsay. That's
So when he's all alone, a thumbs up can be used against you in the court of law?
well, if they don't have any record of it, no one would know. But he took a, because there's a picture of it, right? There's a record of it happening. Does that make sense?
Yeah, but like, well, I understand what you're saying, but
Oh, I think what you're getting at is, does it need to be communicated to somebody else? Is that what you're
yeah,
getting
it's
at?
like you're alone.
Right. I see what you're saying. It's like,
But I mean, they
they're
basically they're allowed to project whatever their meaning is, right? Because it's their story, what they think happened.
Exactly.
That's wild.
It is wild. And Amanda, yes. Well, she says, now that's scary. Remind me never to do thumbs up or peace signs or anything. Yeah, it is terrifying. And this actually came up, I think, in Karen Reed at some point where we were talking about this whole thing that like any type of gesture, if somebody wants to argue that it's a statement, but what's so crazy is it's like there's already an assumption there that somebody made a gesture with the intention of it being a statement, which to me is like mind reading, right? Like it's wild. It's wild. So I know, right? Nonverbal statements count as a yep. Like, so for example, like if somebody, I mean, just think about, right? Imagine if there's like a fly in front of your face or something and you're like swatting at the fly, but like you end up being a defendant in a case of whatever. And then the state wants to be like, that was a gesture of whatever the fuck, right? That it was a statement. It's like, and you might be like, that's not what I was just swatting a fly. You know what I mean? In other words, any gesture could be interpreted however the state wants to use it as a statement for something. And it is wild. It's wild. So yeah. And that's another great point. Proctor's boss thumbed up that shit. Thank you, Mary.
Proctor's, say it right. Proctor's. I can't do a Boston accent, but
me neither. Proctor.
Proctor's.
I love we have double Twiz because he's like typing in the chat while talking. It's amazing. So okay, let's carry on.
Have been recovered.
Santa.
I can tell the court that the defendant's apartment in Pullman was searched as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we're now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, in those compartments in the doors. You can try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside.
You guys, I'll be honest. Most of the time that you wouldn't find that in my car because I keep my car really clean. Just saying. And you don't have to disassemble it to clean the little wells where the doors are. You do not have to to get under the seats, yeah. But to just clean the little well where the doors are, like, he says that as if like that's really the standard for like how crazy clean was this a level of cleaning that's not reasonable. Really, what he's getting to here is the reasonableness standard. And essentially what he's trying to argue is what type of standard would a reasonable person think is like normal for like if you're for a clean car, for like a reasonable standard, right? And what I will say is the way he argues this about the well of the door, it's like you're trying to be like, that's unreasonable if that's clean. Like, how dirty is your car, Santa?
This is like the biggest piece of reasonable doubt I think that he says in this thing.
What you want to elaborate?
Well, it's he's saying there's no evidence in the car, but if he killed people and went to his car, there would be. Like, that's just ridiculous.
I mean, yeah, obviously his point is what he's trying to say is like the reason there's no evidence is because it was cleaned, right? Obviously.
This whole case with Bryan is The lack of evidence is evidence of his guilt, or maybe he just didn't do it.
Yep. There's actually a saying about that in the law. What the lack of evidence isn't evidence. There's more to it than that. What is it? The lack of evidence isn't evidence. Right? Like that's the saying. Like you'll hear that from defense attorneys. So yeah, exactly. The lack of evidence in the car isn't evidence that he killed people, right? But yeah, and also super plainer girl, cleanliness could be associated to autism behaviors or character. Yeah, and the OCD, because that was also mentioned. And I mean, I'm not OCD, but again, my door well thing is 90% of the time, if you were to like do a surprise squirrel car testing of cleanliness, that door well would be clean with no crud. Like that's just one of those things. Like I just don't like crud. And let me just say, this goes back to being a violinist, because when crud to me has like a tendency to be sticky, and like it's a violin thing. Because since I was 3, I've never been able to tolerate having sticky hands, because like you can't touch your violin like that, right? And so it's like a thing that I have. Like I can't handle anything sticky, like to sticky hands, unless I'm like doing something where I'm expecting it. Let's just say I'm like making food where it's expected. But like what I can't handle is like I'm going to go do something and then unexpectedly now I have sticky hands. Like it's like my thing. Anyway, all that to say, for me, that's why I'm like always on the lookout for crud, because crud is usually sticky. That's a long explanation for that. But anywho, yeah. Oh, yeah. And especially right. Exactly. He just drove across the country. Right. And that's the other thing. I don't know about you guys. Anytime that like, if I do a long drive, whether it's like on vacation or like moving, whenever I complete the drive, the first thing I do is clean my car. Absolutely. Because I like a clean car. So that's another great point, Amanda. Thank you for that. For anyone who's like, who's Chaos, in case anyone hasn't figured it out, you probably have, it's Flash, aka DJ Flashy Flash. So.
Clean. There was a bucket of clean right beside it.
That's totally fine too.
I think we can all look to our own cars, you know, in those compartments in the doors. You can try to keep them clean where you put stuff. There's always some degree of crud in there.
Not mine, Santa.
This car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime.
Yeah, so he's really not offering it as consciousness of guilt. He's offering it as he destroyed the evidence, right? That's what he's saying.
In fact, he did a detailed paper on crime scene.
But honestly, I don't care who you are. There's no way. And we all know this. There's no way you could get rid of all of it. There's no way. There is no way. Even if you're like the most forensic expert on the planet, any forensic expert will tell you, you couldn't ever possibly, the amount of evidence that should have, like, I mean, you guys know, I don't even need to explain it. Anyways.
In processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence of 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice aforethought. Manny Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you.
I was surprised he got emotional, and to me, I think it was genuine, but I was surprised. So I think Kat was asking about the disassembling of the car. Yeah, I actually thought about this. Yes, when I think of like disassembling of the car or whatever, what I picture is like taking the seats out. Because that's really the only way you can like disassemble the interior, right? Like that's really the only thing. Seats are made on purpose to be able to take them out. Because, and think about a van, think about a minivan, right? And I don't know that they're still like this, but like when I was growing up, for example, it used to be a regular thing. Like vehicles were made to where you could take seats out and put them in. Like that was a regular thing. Like we always had a row of seats that we would take out of the minivan and put back in. I don't know why. I don't remember why, but that was like a thing. And that's just like one example of like where they did that so that you could accommodate a different number of people or have more cargo space. I think now they've adapted it to where the seats can just like fold into themselves or whatever. But essentially, the way you would disassemble a vehicle is to take the seats out. But if you really want to clean the entire car, the only way to do it is to take the seats out. But in other words, the seats are made to be taken out, and that's possible. Like even if it seems like they're permanently bolted in, I mean, they're bolted in, but you could take them out. And I've done that with my Prius. I mean, again, I had to have someone else do it for me, but yes. Amanda, I appreciate you sharing this with us. Amanda says, I cried during the hearing. I don't know whether Bryan Kohberger did or didn't do it, but I know 4 kids died that night. And as a mom, it would just forever break my heart. Yeah, I think that's incredibly fair. And the thing is that, you know, it is a lot. This is just a lot of things for a lot of people, right? Because it's like, you know, for those of us who really try to stick to the standard of like, you cannot weigh in on it until the evidence has been borne out at trial. I mean, all of us, right? Like I always say it, right? We don't know anything in this case, especially because the gag order, but even if there wasn't, like, we have to wait until trial to see the evidence and then we can assess things, right? And it's like, now that's never going to happen. And then you have this really weird ass this whole thing was very weird. I mean, it was a very, I definitely feel you on that, but there was a lot of like mixed emotions and like, then Santa getting emotional out of nowhere. Like, I don't know, this was definitely a weird one for me as well. And I'm not a mom, except for being a dog mom, but
Do you remember when he sounded like that when he was questioning Edelman?
Like he was going to cry?
Yeah.
I don't remember that. I remember him being spicy. I don't remember thinking he was going to cry though. Personally.
Yeah, I think he can just turn that on and off. Maybe he's the psycho.
He could be. Kat is saying, well, what was the car? I don't know what you're asking. Are you asking what car I have or what car we had growing up? I don't know. Growing up, I'm talking about like a minivan, right? Where like if you've got kids with friends and you need the back row seats, you put that in. But then we would regularly take that out to like have more room in the car if it was just the 4 of us. But my car is a Prius, so let's see what else you guys are saying. That's exactly right. To get DNA out, you would need special cleaners and they would leave a trace. And you would, I mean, yeah, it's just right. In other words, the type of cleaning that went on with my car it would not have gotten rid of any DNA, right? Like that's what I'm saying. It's like your car can be meticulously cleaned, but that's very different than cleaning it so that there's literally no trace of DNA or any type of forensic evidence at all. Like that's a completely different standard. I wouldn't even know how to, yeah, anyways.
Hey, Chelsea, just a random question.
Yeah.
Have you seen the video of Alan Jackson walking around 34 Fairview?
No, I think I've seen that it exists on YouTube. I haven't watched it yet, but what happens?
He just walks, I think he's walking around like the basement and stuff, but they're talking about how like the flooring's all gone and it's just plywood and stuff. It's pretty interesting.
Oh,
but apparently like the owner, like the new owner of the house let them walk through the house. They go through the garage a little bit, like.
Oh yeah,
interesting.
Was that recently?
I don't know when it was. I don't know when it was recorded, but I think it was released recently.
Okay, I feel like that was so. In the first trial, they were allowed. They did have some basementy stuff. The garage, no, but the basement, they did have pictures of the basement, and that did come up in the first trial. So like I feel like we learned in the first trial about the floorboard, like we learned all that about the floorboards and the door frame and all that. That came up in the first trial. But yeah, still worth watching that video for sure. I'll definitely check that out. His car, he took the insides out. Right. I mean, again, like I've done it. Do y'all think I'm a murderer? I've taken the seats out of my car to clean it. Do you guys think I've murdered people? Let me know.
Have you ever taken a picture with a thumbs up?
You know, actually, I don't know that I've done that, but also I don't really take pictures of myself. So there's that.
You're very high up on the sus list now.
Uh-oh. Oh, Jackson was yelling outside to see if you could hear the sirens. Oh, I'm sure you could. I mean,
yeah, I saw a picture recently with him standing in the yard and somebody took a picture, I'm assuming from Bryan Albert's room, which is what they said it was. And they're saying that you could hear everything.
Yeah. Given the way that the layout of that street, I would imagine the acoustics for outdoor acoustics are surprisingly like, because sometimes outdoor acoustics, it can vary, right? Here's an example. Where I live, if I'm outside, like literally if a leaf falls from a tree up way on up the road and lands on the road, it sounds like it's completely amplified, and it's like startling. It's crazy. And it has to do with the way where the buildings are located. Everything is like amplified and echoed to where everything sounds really loud outside, especially at night. It's crazy. But like in other places, if you're outside, and again, like as a musician, this is like an actual problem. Like I would be hired to play all these outdoor weddings, and there would be like no buildings around, right? It's just like tons of grass, say, and then they put the little chairs out, and it's like, no matter what you do on the violin, no one can fucking hear it. It's like, it's crazy, right? So from an acoustical standpoint, you know, I've learned how to understand what to expect in certain acoustical places outside. Anyways, what I can say is from looking at 34 Fairview and the way the houses are situated, I would expect it to have much louder acoustics than a lot of other outdoor places, if that makes sense. Just from what I've seen, because I've had a lot of experience trying to test the acoustics outdoors. Like you guys don't even want to know. It's kind of insane. Chelsea's wanted in 12 states, and that's not even my real name. You got me. You got me, Flash, aka Chaos. Causing chaos.
I just read that Steve G has threatened Bryan Kohberger in jail.
Where'd you read it?
Twitter.
From who?
I don't know if it's true or not. I'll believe it though, but I'm sure it's on video or on his Facebook family page, so we'll see it eventually.
Oh boy. Interesting. Okay, let's keep going. We're almost to the end of this hearing.
All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation.
So this is what Lori Vallow did. We talked about this last night when we went through the plea form, and I was like, oh, pretrial investigation. You know, Lori Vallow waived that, and that's like never done. I literally commented on that. I was like, yeah, that was so wild. Like no one ever waives it. He waives it. He waives it.
Yes, Your Honor.
Crazy.
The state also?
Yes, Your Honor. The state does not believe pre-sentence investigation is needed given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. We have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties.
They just talk about the scheduling. They go with that. They're going to talk about here in a second, though, the gag order bit and this whatever.
July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public.
Really? You guys think there'll be interest, guys? What do y'all think? Is anyone going to be interested?
and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order?
No.
Your Honor, I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
Would have no objection for the order to remain in place through
All right, I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant where it would be revoked.
I want to note something. He mentioned the non-dissemination order. Just to be clear, the non-dissemination order is different than documents being sealed. Okay? The non-dissemination order just deals with talking to the media. So here's the thing, and I don't know that they actually mention this unsealing of documents. We're going to listen to the rest of this, but I don't know that they mention it. I think it would stand to reason that things will get unsealed as time goes on. But in other words, I just wanted to make sure that everyone understands the non-dissemination order is completely different. Non-dissemination order is like the attorney, y'all know, right? But like the attorneys can't talk to the parties cannot talk to the media and whatnot, right? They're in their ability to make, and that's why he even says, I'm sure you guys will want to talk to the media or whatever, or the media will want to talk to you. The documents that are sealed is a completely different standard. And I am sure there will be some documents that will probably never be unsealed. Especially when it pertains to things that are super graphic, like with the crime scene. But there are definitely going to be documents that just will be unsealed and should be unsealed. And it'll be a matter of when. So let's just see if they provide any more information on that one.
Prior order allowing him to come in civilian clothes is revoked given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
Yeah, they don't.
I assume that the trial date will be vacated.
trial-
and the 4 jurors will be released.
The
So
trial
they do not mention anything about unsealing the documents.
will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you.
that's it.
Yeah,
Again,
the normal thing, right, would be for things to be over time, like after the sentencing, for things to be released over time. But there were a lot, what differentiates us from other trials, for example, is like there were a lot more filings in this trial in general. And there were also probably a lot more filings that were under seal than you normally see. So it's not going to be so easy. I think they're going to have to really talk about it. And hopefully we'll learn what happens with that.
would all please wait for the parties and the victims' families and others to leave the courtroom before you do. I would appreciate it. And with that, we're adjourned.
And that's it. So the other thing is that, yeah, the FOIA. But what's been stopping them from being FOIA'd all along, though, right? Because anybody can submit a FOIA request for anything, you know what I mean? I'm trying to think. I don't remember exactly how that goes with the FOIA. But I was going to say another thing, too, right? As far as the victim impact statements. Yeah, I was thinking about this as well for those of you guys who are kind of like, oh, man, I'm kind of terrified. You know, I have a lot of feelings about victim impact statements. Those of you guys who've watched other trials with us here, you know, we've seen a lot of variety. And here's what I will say. I can say with complete confidence that it will be a struggle for me to listen to Steve's statement. And I honestly, I was literally after this finished and I went back to work and I was doing documents and stuff. And then, you know, I was just, in my mind, I'm always thinking while I'm thinking about other, like I'm always thinking about a lot of things at once. It's like in the back of my mind, not like consciously, but in the back of my mind, I must have been thinking about victim impact statements, because literally I then stopped what I was doing and I had the thought and I was like, I don't know that I'll actually be able to watch it. I don't know that I'll actually be, I mean, I will make myself, because we have to cover it. But let me just put it this way. If I wasn't covering this case and this, what would have been a trial, if I wasn't covering this, if I was just watching it, like, because there's other trials that I watch and not cover. If I was just watching it, I would not watch his statement. I would skip past it. And maybe others as well. I don't know. But I can guarantee you I would not watch his statement, because I think it's going to be tough. Anyway, I'm not going to put words, I'm not going to say. Anyways, but I will get through it for you guys and we will get through it together. But I am not looking forward to it. We'll just say that much. So that was cool. He told everyone else to wait. He could, before sentencing, normally after the victim impact statements, and after everybody's, both sides are going to be able to make argument to the court and they're going to have the victim impact statements. Normally the last thing that happens before a sentence is handed down is the judge has the opportunity to say things. And it's totally up to them. Some judges, they don't say much at all. Other judges, they really let the defendant have it. Now, here's the thing. The fact that in this case, there's a plea deal really gives Hippler, free reign to let him have it more so. If you had a situation where a defendant was convicted through a jury trial, what the judge says at sentencing can be problematic in the sense that, like, there's still going to be appeals and whatnot, that are going to be happening. And, anyway, it could show that the judge was biased. For example, when if the judge says something like, I knew all along you were a monster. I don't know. I'm just trying to think of an example, right? Anyways, it can be problematic. The thing is that when there's a plea deal like this, there's like, he can say whatever, he can say as much or as little as he wants, and he can really say whatever he wants. And it's like he's bulletproof in a way, like there's nothing that can go wrong to come of that. So it'll be up to him how he wants to handle it. But typically, when that moment for the judge to speak to the defendant will be like the last thing that happens, and it'll be right before they hand down the sentence, or they might hand over the sentence and then give their thoughts. But usually they're going to give their thoughts first, especially when they're handing over a harsh sentence, or for example, in a case where there's some leeway, if it's like they're going to go with the maximum, right? And it was like up in the air, like they might say all that because they're about to just, you're like, oh, okay, yeah, they're going to go with the max because look at what they're saying. They're justifying or giving reasons for why they came to that decision, So, yeah, I know it'll be tough, but we'll get through it together, guys. And if we have, we will do it. We will do it, and we will work through it, and we'll, and actually, if nothing else, I just have to think of it this way: it'll be an opportunity for me to challenge myself, and I'm referencing getting through Mr. Gonzalez's statement from what I expect it to be, like using my imagination, right? I would love to be wrong. I would love for him to surprise me. But from what I can imagine it being, I think you guys know what I'm saying. At least on my end, the way that I will try to approach it is like, this will be a good challenge for me to get through it and get through it. Find a way to get through it, like just that in and of itself. And we'll talk about it. And that's exactly right. I was thinking about this, right, Amanda, that Judge Newman was burning Alec. I know. And a lot of people, his defense attorneys tried to use that as like, part of their appeal or whatever. I mean, again, it wasn't going to go anywhere. But in other words, it was an example, though, of what could happen. Like, Judge Newman didn't really do nearly as bad as he could have. Like, it could have been a lot fucking worse. It could have been a lot worse. But it at least was an example of defense raising that as what they perceived to be an appellate issue that was not an appellate issue. Play the penetrometer video. You got it. You got it. Oh, Poorhouse Becky's hearing is coming. Thank you, Amanda. I've been meaning to look that up because I don't want to miss it, and I did not know. Thank you. She's saying her hearing is coming up. Awesome. We will definitely cover that. So we got a request for the penetrometer. Where is it?
Hard as a rock, freeze thaw effects on penetrometer resistance. You know, his head's as hard as a rock.
Your Honor, I can't do this in 2 minutes.
Also, real quick, we're gonna.
I ate a lunch, like I had a whole delicious lunch.
Is there any way that you would think
somebody tried to kill my ex-husband? They should be prosecuted to the full extent of the law.
Famous last words, Fievel. They're coming for you. Thank you so much for getting me on to the Wendy train. Whoever Twiz did that without even meaning to. Twiz was like, play the penetrometer video, and then now I'm on my saying, right? They're coming for you, Fievel. I mean, look at her. Enjoy fresh air while you can, or whatever they say. So anywho, Gretchen, welcome. I believe you're a new squirrel friend. Happy to see you. Or have you been here before? But happy you're here. 32 seconds long. Oh yeah, you got it. 22. You got it. You got it. Your wish is my demand, guys. This is where we make dreams come true. Let me find it. Where is it? Where is it? There it is. Here we go. I've got a lot of these, guys.
That call is actually from Brian Higgins to you, isn't it?
Yes.
Obviously, you know how long 22 seconds is.
What's that?
You know how long 22 seconds lasts.
Yes.
Kim says you were looking up my Disneyland. What does that mean? Disneyland? What? What? I don't know what that means. Why are you muted? I didn't mute you. Can you try to say something, Twiz?
No, I was muted like during that video, but like as soon as it stopped playing, I was unmuted. So it must do it automatically.
It does. It does it to me too. It's these media assets. It's the StreamYard thing. The media assets, whenever there's a video clip, it automatically, I don't know why, it automatically mutes everybody. You can't, there's the only way to, yeah, that's, it just, it's automatic. So, yep, I know it's frustrating. I don't know why they have it like that. Let's see. We've got, what else have we? Oh, here we go.
Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it.
You're just a tad slow on the rebound. I don't think you're slow. But welcome. I'm happy to see you. I was on, what are you guys talking about? So I mentioned Disney World earlier because Amanda had said something about going to Disney World, and I asked if she'd been to Disney World yet. I don't know how else, though, Disney World or Disneyland has entered the conversation, but nothing wrong with that, you know? Oh, yeah, I'm not related to whichever Whitaker family it is. I am not related, but that's interesting. Hoss long to plant a sheath. I don't know. Couldn't tell you. 22 seconds. Hold on. I think we probably got some other ones. Fender's here. Hi, Fender. We love you, Fender. Let's see.
Your Honor, I can't do this in 2 minutes.
Love it so much. Love it so much. One more wildcat.
You also told him that you thought you heard a wildcat, but maybe it was a person or something like that as well?
No, that's not what I said.
What did you say then?
I said when I went outside that there's a house cat that's gone wild, and he hangs around. He goes from hanging around the shop, goes from hanging around the house, different times. You might, and there'll be times you don't see him. And he had been around the house. Mm-hmm. And when I went outside, I believe that cat was over there.
I love it so much. I love it so much. So guys, hopefully Kane is still Yeah, Fender has a new command. Hopefully Kane is still live. Let me double check because again, this should redirect you guys. And I will be popping over there in the chat as well. I need to do like some regular adult things. Like I need to do some laundry and I need to get some, I need to check some emails for the law firm and do a couple other things for that. And anyway, but I'll be in the chat as well though. But let me see if he's still live. And this should redirect you guys if indeed he's still alive. That kind of right. I think he is. Looks like he is. So yeah, he doesn't even know unless he somehow heard me. No, there's no way he would know. This will be a surprise. So essentially, yeah, we will pop over. Hey Twiz, you better come back again now because we had our Twiz reads and we're never gonna ever be the same again because it needs to be a regular thing. So
feels like a threat.
It is a threat.
I was just threatened.
Yep. It is a threat. Yep. You missed it, Fender. For anyone who missed it, if you like whenever on replay, if you go back to like the early in the stream, you'll get to see the Twiz Reads segment, and it was fire, as the kids say. Do they still say that? Twiz.
No.
Twiz.
No, you can't hear me. What?
Do they still say
what do we
that?
say?
Do the kids still say fire?
I don't think so. Well, maybe. Define kid.
Does anybody know what the oh god. I don't even know anymore. What generation?
Do kids say fire? They probably do. Some of them, I don't know.
Does anybody know what the kids say? Good night, Mary. Who's gonna fall asleep?
I know Riz, and then out of pocket, and
out of pocket.
what's the
like
other stupid stuff they say?
Insurance, like
out of pocket. I think like it's when you say something crazy. I still don't understand like the exact meaning of it, but like Riz, yeah, I'm sure they still say Riz. Out of pocket. What's the what is it? Low key.
You guys remember
low key
Da
type
Bomb?
stuff?
Do you guys remember Da Bomb and Raising the Roof? Oh my god, memories.
Dude, we still raise the roof and it's still da bomb.
Thank
I
you.
don't know. Maybe I'll turn on Twitch and hear what the stupid little kids say nowadays.
Lit. Yeah, Lit. I remember Lit. Lit was like what, maybe 8 years ago or something. Riz's charisma. Thank you, Fender. Of course Fender would know.
Did you not know that?
Fender has Riz. No, I asked you what Riz was and you said you didn't know.
When?
Just 10 seconds.
I must have thought you were talking about something else. I knew that.
Okay. You knew that. No, you're just saying that because Fender gave you the answer.
No, listen, I worked with young kids a couple years ago, so like I heard some shit.
Likely story.
But like the thing with Riz is like, oh, I'm always rizzing up chicks and it's their charisma. I've known that for a long time. I will fight you right now, especially because you threatened me.
Oh man. She's asking a youngin'. She's asking a kid. They say Riz. We got it.
Everything they like, every other word they say low key and bro. They say bro a lot. What else? I don't know. I've noticed one thing. The more that time goes on, it like the stupider kids' sayings are.
Bussin'? Is that a saying? Maybe no. Bussin'?
I really only hear bussin' from a certain nationality of people, and it's food related, I think.
Groovy? That's like from the 60s, but I don't have any problem with that. Drip? I have no idea, you guys. I'm not cool enough for this. Oh, they say bet a lot. I've heard that. I've heard that from some people. Bro is funny though, because again, that was one that was popular when I was young. Bro, that's been around. It's been around. Jive turkey. What is Flash just?
Oh yeah, cap.
Oh, cap. What the fuck does that mean?
Lie. Like if you said, like if I said Bryan Kohberger's innocent, and then people that think he's guilty say cap, like that, like I'm lying.
Weird. How the fuck did that end up meaning that?
think it has something to do with texting because people always send like the blue cap, but I have no idea.
That means lying?
Yeah.
I mean, I would think like the thing with the big nose would be lying if you were to send an emoji. You know what I mean? Like Pinocchio nose. Kim says I'm bringing dude back. Love it. I think I say dude still though. Do you guys hear me say dude?
Dude never left.
Hey.
Or maybe like I just don't hang out with kids. I don't know.
Wow.
I swear that as long like the longer time goes on, people get stupider and stupider though. So
Janelle coming in clutch with the nose. I love it. Thank you. That is thank you. See, if you're like one of the kids and you want to comment that somebody's lying, you just need the big nose. Who wouldn't get that? And you know what? That could count as a statement, right? Because we talked about this earlier. What is that young gravy that's bussing you guys?
that's bussin'.
Bender, that's a scary thought. The kids don't even know who Pinocchio is. I can't even, what? Kids these days. The kids these days.
Neato. We need to get like English slang though. They say all sorts of crazy shit.
Oh, I love English slang. That's my fave. I wish I could think of some. I can't think of any. But I have English family, so I hear that, but it's just been a little while since I've seen them. Irish stuff is good too. Yep. Also, shout out to shout out to Black Widow. That's what I was gonna say. Shout out to Black Widow. He represents.
I saw her yesterday and she didn't respond to me, I don't think.
Was there a lot of people in the chat?
I mean, yeah, but like that's not a reason.
I'm sure she didn't see it. Otherwise, she definitely would have said. She would definitely would have responded. 100%. She's amazing. And maybe she was in top chat. God, fucking top chat.
Yeah, that could be. I think it was Defense Diaries or something.
Oh yeah. Well, then there's a lot of people there yesterday, I'm sure. Right? Or whatever day it was.
Yeah.
Durble. Asked my dog if she wanted tea tonight. We got tea. It's fucking funny. We love Black Widow. We do. Black Widow. Uh-oh. I didn't get my W. Thank you, Fender. There it is. That's
Defense Diaries. I don't know
some
about
reason,
them.
Kim, I thought I misread this initially, and I thought that you said that you love old English slang, and I was about to get really super nerdy. And I'm glad I reread this, and then I realized it just said English slang before I started talking about old English slang, because that's like a whole road we don't need to go down. So I'm stopping. Is there a summary sentence? Hey, Fender, do the AI thing for Just Beth. Do the AI thing, pretty please. Fender has a thing that the AI can do a summary. I would love to see it's always like, who knows what you're going to get with this? We're at the end. We've been here and we're at the end of the hearing and we're about to redirect into King's live stream. Shout out to the Rat Daddy. But first we have to see if Fender can provide us with an AI summary. Thank you, Gretchen. Bloody twats are mental. Okay, let's even, hold on. Bloody, I can't, now I'm laughing. Now I can't do it. Bloody, Twiz, help me out.
I can't do British.
I could do it, but see, now I'm laughing and I'm trying to not laugh. My face wants to laugh, and now it's all just fucked.
Have you seen Eurotrip?
No, but you've talked about it.
Dude, when they're on the bus with that one weird dude, it is so funny because he's just like, "What are you saying?" I'll get the clip of it sometime.
You've sent it. No, you've sent it to me. I've seen the clip. See,
not that one.
Are you sure? Because I was having deja vu.
I think I've sent a clip of the movie, but not that one. Maybe I have, or maybe it was on a big long thing. I don't know.
What the fuck?
But it's really funny.
Fender, what is that? What is that supposed to be?
She took a tradesman through the trifling sentence and tried to lick me eyeball. It is so funny.
I know, right, Santa? So here's what I will say. If I don't know that I can summarize in terms of what happened, like I said this earlier, I think this is all about trust or distrust. And I'm making this is a huge ass summary, but I talked about this last night on the live stream. I talked about it throughout the live stream today. And so, in more elaboration or what have you, right? But I think this is all about trust or rather distrust, that the state does not trust their case and did not trust their case to get a conviction, and that the defense did not trust that they could get to seat a jury that would be fair and, and objective and understand the presumption of innocence and reasonable doubt and all that. Again, comparing it, Richard Allen jury versus Karen Reed, the retrial jury. I think that they did not trust that they wouldn't be facing a jury that's like a Richard Allen jury, and that the knife sheath would have been a done deal. That's what I think, in very much summarized fashion. Twiz, have you any Baba black sheep? Have you any coal? No, wool. It's wool.
After
Twiz.
what Bill Thompson said today, I'm still wondering how he was ever arrested.
For real.
Why the defense took it, I don't know. Maybe the jury had something to do with it. I have no idea.
Yeah, and the other thing too I mentioned before is like the most recent filings on the docket prior to the notice of hearing or whatever were related to the jury questionnaire, and they were like defense objections to the jury questionnaire. So that's interesting. And yeah, like I said too, the fact that the state has conceded that they do not trust their case and that they don't think they could prove it to a jury beyond reasonable doubt means that they shouldn't be bringing the case at all, right? Like again, shouldn't even be here. They shouldn't be doing it. That's not what their job is. Their job is to try a case when they are confident they can get a conviction beyond a reasonable doubt. That is their job.
A bottle of water. I can't do it. One of my favorite movies though that came out recently is Bullet Train. And their English accents, that is so funny. You haven't seen Bullet Train?
No.
It's like the only really good movie I think that's come out since like Inception. It's awesome. You should watch it. Why did the defense take the plea? For whatever reason, they felt it was the best decision that they could make.
And also,
further than that, I don't know.
The only way to guarantee saving his life. We have to remember the job of his defense team, first and foremost, is to save his life, point blank. And all of their motions this entire fucking time, right? All of their motions, first and foremost, what are they trying to do? Save his life. And honestly, and they did that. Like, if you have to think about it, if you're his defense team, they should be going home tonight and looking themselves in the mirror and being like you should feel like you can die. You've done well with your life. Like, if you've done nothing else, you've saved a life. You know what I mean? Like, this was their goal. And that is literally first and foremost, that was their job. That's what they were going for all along. That is their assignment. And they were successful, right? So there's that. Truth Seeker, welcome.
Well, okay. If their only goal is to save his life, we're going to go 2 scenarios, and he's guilty, right? He did it.
No,
they could
not
have done this a
necessarily.
long time ago.
Oh, you're giving me 2 scenarios. Sorry, I'll be quiet.
Yeah. But if he is innocent and he didn't do it, there's no, I would just, the case is shit. Reasonable doubt shouldn't be that hard. Take it to trial.
It's the jury. I'm telling you.
There's no way. No, there's no way that juries can be that bad where you are that scared. All you need is one to not get a conviction. All you need is one.
I wouldn't be saying this, and I will be honest. It changed for me with Delphi and Richard Allen, because honestly, I have to say that, and this is a huge thing to say, they had even less in that case than they do here. And that's saying a lot. They had even less. So the fact that they got a conviction in that case, that has changed the perspective for a lot of people, but myself included, where you it's possible, right? Like, if you get a jury like that, they could pick the fucking selfie with the thumbs up and be like, conviction, death penalty. You know what I mean? Like, they could fixate on one thing that is that anyway, they can ignore.
Yeah, but there's 12 of them. There's 12.
They did it in Delphi though, Twiz. They did it. They had 12 of them in Delphi.
I know, but like that's got to be an outlier too, right? Like
I mean, I
that
would
can't be
hope
the
so.
common thing.
I would hope
I don't.
so.
I'm just saying I would have risked it if I knew I didn't do it and there's this case is this shit. I would risk it because then you still have appeals and stuff like guaranteed. It's not even like you have to try for it. You have a guaranteed appeal. I don't know. All I know is what he did, right? It's his choice. It's not Ann Taylor's. It's not Masloth's. It's not Bicca's. What he did was his choice. And I will assume because I would make the best decision for myself. You would make the best decision for yourself. I will assume most people in chat would make the best decision for themselves that they could. He agreed to the plea deal. He thinks it's what's best for him. I don't know why. I can't explain it, but I respect it because that's what he wanted. So
well said, Twiz. Well said. That's exactly right. Well said. And I think that we can all agree, like, yeah, that's what it comes down to. It was his. We don't. I understand wanting to know the reasons. It makes total sense because this is completely crazy that this is how this is ending. However, we don't need to know them. And it's exactly. And the other thing too, right, is even though this seems like this came out of left field, you have to remember that this is something that they would have been talking about this beforehand. And it is something that he would have been thinking about because this is always, it's just one of those things. Right. And so, anyway, Twiz, you said it perfectly. I should just shut up.
there's I don't know if you are aware of, give me a second. What's that dude's name? John Kirikow. He was a CIA asset. He was the guy who went to Iraq or Afghanistan and caught like who they thought was like the number 2 of Al Qaeda in the war, Al-Bu Zabari or some shit. Like super high up in the CIA, really good at his job, right? They came to him and were like, do you want to join our advanced interrogation class or whatever? And he was like, advanced interrogation, what's that? Well, it turns out it was torture. And he said, no, like that goes against the Geneva Convention. Like that's illegal. Right. And when the torture program got released to the public, they tried to pin it on him. This dude is completely fucking innocent. Didn't do shit. They knew it. He knew it. Everyone knew it. He goes to his attorneys because this is in the DC court where they have like a 99.99999 conviction, and everyone on the jury will always be like other government employees, so they're always going to agree with the government.
That's also federal, right? So that's the DC
Correct.
circuit. Yeah.
So he was like, no, like he's gonna fight it and fight it and fight it. And the day of the trial or something, they came with a plea agreement. And he was like, no, I'm taking this to trial. And his attorneys looked at him and said, this isn't about justice. You think it's about justice. Take the fucking plea. It's obviously there's more to that. I don't remember exactly what happened, but it's not about justice sometimes. It's about winning. And he took that plea. He had to do a couple years in federal prison. It's a wild case. John Kirikow, look it up. There's a few really good interviews that he's done on YouTube. Like, it's amazing.
Like I said, going back to the whole idea of contracts, right? Like what if you take the whole like idea of like the emotional element or whatever out of it, if you like, in other words, like if you're a defendant, right, and you just literally look at what do I stand to gain, what do I stand to lose, like what you're referencing, Twiz, right? And that whole idea that we were discussing, like with contracts and leverage, if you can take it, like let's just say you're factually innocent, right? But it's like, again, let's just say for an example that you might end up with the death penalty, and let's just say that that's not how you want to go, right? There's some, everyone has their own thoughts on what would be worse or whatever. And if you're a defendant, you're probably reflecting on that. Gee, which do I want? Like, you know what I mean? But anyway, if you're like,
even the victims' families have been saying this isn't about justice. It's not about the victims.
Right. Well, yeah. I guess they're saying that in a way that like, that's correct, but I think that's not how they mean it, right? You know, like they think.
I mean,
it
it's
should
in different terms because obviously they think he's guilty and they want him dead, right? But
Right.
the principles, because it's not justice for Bryan, it's not justice for the victims. It's about the court system and the prosecutors
Right.
getting their win.
Right. Well, I mean, justice shouldn't just be about prosecutors. Well, okay. In a perfect world, right? Prosecutors would only be bringing forth cases that are solid and that, you know, like again, like thinking about like the feds, right? Like what you were referencing in DC. It's like where it's like, okay, if they're trying a case, it's like going to be just really fucking solid. And it's like almost a conviction is like almost a guarantee, but also it's also a guarantee that the person probably did the thing, right? Or beyond probably, right? Like that's a whole thing. The federal cases are known to be so much stronger and more solid than state. And actually, I heard a story about this. Who was it? Anyway, it's like a thing, right? Where if there's a case that's like not good enough for the feds, then they might be like, the state might try it because it's good enough for the state, right? It's just a different standard. So anyway, like ideally, you shouldn't be bringing the case unless it's like almost a guarantee. It's like an open and closed case, right? Like it's all there. But the problem is like that's just not what happens all the time, and so then it just warps everything. You know, Karen Reed again being a great example of that, because justice is not always a conviction, right? Obviously. And the thing is like if you're the state and you're like, oh, justice is a conviction, and you're also trying these cases that are problematic, have holes in them, right? Anyway. So, but you guys know how I feel about that, right? Like it's obviously just, what do I say? An injustice for one person does not equal justice for another person. Like that's what I always say. So, you know.
Yup. It's crazy.
So, are you sick, Gretchen, or is this like your stress level from this case? Because I can see that being also a thing. Yeah, his plea includes no appeals. The only exceptions that, from my understanding, is like he could still do like an ineffective assistance of counsel. However, I'm saying
there's like
because
2 or 3 of them or something
they
that
were
people have
very-
listed.
But in the colloquy, right, we all heard him say in multiple different formats that he's very happy with his defense team. You know, but
Who? Bryan?
Yeah.
Oh yeah, dude. I'm getting so pissed at people talking shit about Anne. Oh, Anne could have done that. Like, do you know the evidence? Do you know the situation they're
No,
in?
she
No,
was
don't try to question her.
Yeah, no, she was, and the thing, like, he is right. He's in the, like, in other words, when he's like, yes, they were amazing. I couldn't say, like, you know, like he was.
I might be a little biased, right? Like y'all know why Andrea Burkhart is awesome, right? Well, guess why Ann Taylor's awesome. Just saying.
She shook your hand.
She shook my hand. She's awesome.
Yeah. Best day of her life. You know, and as we know, the standard for that, for ineffective assistance of counsel, is basically your counsel must have been basically dead in order. It's like a really tough thing to get. But then the other thing is there could be like your habeas petition. So basically, the appeals, normally there's a lot more. There's just more options, obviously, available on appeal, especially in a death penalty case, and that's waived. So, Twiz makes everyone have the best day of their life if they get to shake his hand.
For real.
I also love Andrea Burkhart. She's amazing. Okay, guys, Frodo's asking me to go out, so we're going to go ahead and wrap this up. Again, this should redirect you guys over into Kane's stream. I can't guarantee what will or will not be happening, but it will be crazy and fun, and you'll definitely see a lot of Squirrel friends there. And Kane is awesome. We love Kane. Shout out to the Rat Daddy. And so... And so, yeah, also Twiz, you better come back now. That is a threat on the record. It's a threat.
That sounds like a threat. Dude, I'm so sick of it. I am so sick of it. And Taylor could have done this. Do you know the evidence? No. Then how do you know that you could do a better job?
Yeah, I find
Because
that
none of us know the evidence.
I mean, not
None
only
of
that
us.
though, but look at how many filings and how I mean her filings were we read them all. They're phenomenal. They're anyway. People don't know what they're talking about. That's
I
what I
know.
will say.
I'm just
You
tired
know?
of it though.
She's amazing. I'm tired of it as well. She's amazing. Okay, guys, I love y'all. Squirrel Crew, y'all are the best. We will be back together soon. So happy to see all of you guys. Squirrel hugs to everyone. And until next time, Squirrel and Twiz out.